Greetings, 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 greetings. I desire your King, King Clifford Jefferson, ascended of Godfrey, the fifth caravan Jew, the son of folk, the ruler of Jerusalem. I am the reincarnation of King Edgar the Peaceful, which we know as Jesus Christ, the King of Peace. It is November the 29th, 2023, which is in the Berber year. It's 2973. This is another day in which we get to honor our forefathers, those who have paved the way for the English subjects or the English heirs. Um, this is another marvelous lecture that I'm going to present to my subjects, the English people, Anglo-Saxon Berbers, all those who are going to be privy to this. I suggest you watch the last 5 videos that I did because I'm going to pretty much exemplify that information in this present one. All right. So that means that we're going to go back over some of that material. All right. To bring it home so that you can close the gap or the space and the gap or space in the time of your understanding, which you were not privy to. All right. I just want to give a shout out to all the faithful members of the English Third Temple Church of England. I'm going to shout out to my family, the Jefferson family, all those who bear that noble surname, whoever you are. It's very important for all those who are viewing this podcast to make sure that you take this information to other avenues, other roads that you travel down, seeking information, for guidance, and in this present day, those roads or avenues are usually what we call YouTube or TikTok or some type of platform. All right, because in this day and time, majority of us as under the misnomer as Negro, Black, Colored, Ethiopian, we don't pretty much observe to the churches as a result of the misinformation, the darkness that's told about the church, as well as the overseers of the church. That problem has always existed from a time which we knew not about. And as a result of that, this is why we're in a predicament or the situation we're in now. And this is what I come to correct. Today, we're going to, once again, revisit the last 5 lectures that I did, as well as talk about some important aspects of the information that I spoke in my last 5 lectures that are all associated with what we call the trust, or what we call the public trust. The public trust deals with the inheritance, which is what we call the property. The property is what we call the land, and which is now what we call real estate. The land is very, very important because it goes all the way back to a time which we knew not about, and that's the problem. Reason why we can't claim our estate. All right, we know that the estate were left for heirs, and we know heirs are the sense of the body. Okay, heirs are descendants of the body, and as nationals here in North America, and claim to be heir as nationals here in what we call America, we know that America is not a nation made of nationals. The American term for national is naturalized citizens, which is a synonymous with what we call foreigners. All right. All you have to do is look up the word Americans on Wikipedia, and it clearly shows you that the denotation to the word America has nothing to do with any genealogy or ethnicity or place of origin. It only has to deal with the characteristics as stipulated in the 1790 statute called the Naturalization Act. Okay, so this is your original United States, which consists of what we call the 13 colonies. The 13 colonies at their original birth state was under what we call the Articles of Confederation, which was a weak and central government, which we know that at that time, their frame of government or their style of government was nothing more than an ideal or idea. All right. It didn't come to fruition until 1789 with the creation of their constitution. All right. We know that the United States, or the area which we now term or deem the United States, composed of the Union of States, which is originally 13 states, uh, were under different constitutions. All right. We know the constitutions that we now have uh, for each state within the Union are under the authority now of the United States Constitution. And we know that the only sovereignty that the states have is that they did not surrender to the what we call our government. And we know that that government that and authority that they have that was surrendered to them by the colonies was the king's royal prerogatives. All right. So it's very important to understand that, as heirs to this land, and this encompasses a lot of groups, uh, foreigners, Scottish, Dutch, German, French, Spanish, as well as those who classified what we call Native Americans or indigenous Americans or Aboriginals. All right, these terms must be looked at very closely in regards to some type of inheritance claim to be had here on this particular land, because we know that your present government only occupies this land by way of what we call prescription of sovereignty. Prescription of sovereignty, which is a non-possessory use by way of what we call easements. We discussed those terms before, so if you haven't heard them before, please write them down and go and research them at your own time. At your own time. All right. So as I said, we're going to talk about a lot of stuff today. I try, and I promise not to hold you long, but we're going to talk about the cess-tu-que, which is the trust for heirs, which are also known as beneficiaries. All right. And we know that the trust has to deal with some type of property. You have personal property, we have real property. We know personal property is the tangible things. We know real property is things that's not tangible. We know real property has to deal with real estate, which is buildings, fixtures, lands. All right. And all those um, terms in real estate are associated with what we call a bundle of rights, all right, which are homeowner rights or land ownership rights, which are denoted by what we call a deed or some type of instrument showing that you have the authority to that right of possession. And we know that the word possession means property. Possession means property. All right. Possession means property. All right. So we're going to get some clarity once and for all on who owns what in regards to real property, because we know there's a difference between real property and what we call real wealth and what we call paper wealth. Once again, we have real wealth and paper wealth. Paper wealth is associated with what we call the monetary system or some type of instrument that denotes to some type of legal tender or some type of medium that can be used as a barter, as a result of using a barter system. Okay, contrast to what we call real wealth. Real wealth, as I said, is land, building, fixtures, and in this day and time, real wealth can only be obtained by what we call paper wealth. All right, whether it's real property or personal property, it can only be obtained by what we call paper wealth. All right, some type of instrument, negotiable instrument that can be used as a medium of exchange between the buyer and the seller. All right, in regards to obtaining some type of possession. And we know possession in regards to what we denote to some type of inheritance, and its fullest extent is reserved for what we call land. Okay, land, Land. Okay, so once again, we're going to associate this with uh, Native Americans. Okay, Native Americans specifically, because Native Americans are claimed to be indigenous here before the so-called colonists came here on their explorations. And we know that when we're dealing with colonists, we're dealing with colonization, going back to the age of what we call discovery. And most of that was done on behalf of what we call French and Spain. Okay, French and Spain. All right. Then comes Dutch, Swedes, Netherlands, etc. All right. And then came what we call the British colonization here in North America. All right. In the 16th century. All right. So there's a time line that has to be closed in reference to the gap of the mental understanding that what took place at that time on that timeline. Okay, so I come to um, delineate that timeline and close that gap of your misunderstanding about the information and that evidence is going to be based off precedents. All right, the evidence that I'm going to bring forth before you is going to be based off precedents, which is the evidentiary fact. All right, the only way you're going to have the right to suffrage is evidentiary facts supported by precedents. All right, and even if there's no precedents, no one has the right to be denied suffrage. The only way you can be denied suffrage is by way of what we call ignorance of the law. The only way you can be denied suffrage is by way of what we call ignorance of the law. And ignorance of the law about distrust, i.e., the public trust, i.e., the SES2K, i.e., the public trust doctrine. So without further ado, let's get started. I'm going to be sticking and moving. So all those who are following along, please take your notes and write them down accordingly. But at the same time, try to keep up with the speed I'm going at for the sake of time, the time that I have to teach this lesson. All right. The SES2 is a shortened version of SES2 use the fiefament fiat, literally the person whose use to benefit the fiefament was made. In modern term, it corresponds to a beneficiary. It is a law of French phrase, a medieval English invention. You hear that? It's a law of French phrase, a medieval English invention, which appears in a legal phrase, SES2 trust, SES2 use, or SES2 via. In contemporary English, the phrase is also commonly pronounced setike. All right, let's move forward. Let me read this way. I can go right here. Now I want to read this. Once again, I'll make sure you guys seen that. You go back up here. A SES2 is a shortened version of the SES2 use le fiefement fouet fiat. Literally the person for whose use the benefit the fiefment was made. So we know a fiefment is a fief. All right, it's a letter patent, which is usually results in what we call a feudal tenure. All right, under feudal laws. We know feudal laws under feudal tenure came in with the William the Conqueror in 1066 through what we call the Norman Conquest, which is the practice being used here in what we call North America in this present day, i.e. in the state of New Jersey. Any such in-trust legal status was partly to circumvent the statutes of mortmain, which sought to end the relatively common practice of leaving real property, land, milling rights, market, fisheries to the church, meaning any of its branches, on the tenant's death so as to avoid dues, i.e. taxes, i.e. debt, i.e. the king's revenue, inquisition post-mortem, which could unpaid lead to reversion, repossession of the tenancy to the landlord. Two concepts explain the origin of mortmain. This means dead hand. First, it can be categorized as referring to the deceased donor and former owner and their desire and their will that the church inherited. All right, this is called the English throne, or what we call the crown. All right, the English third typical church represents the crown, which is the corporation soul, which is in charge of all church property, known as what we call entail estate. All right, known also as crown land. Crown land is an entail estate, which means it's inheritable. Second, as a church, a non-natural person recognized by the common law, i.e. a corporation, never dies. The land never leaves its dead hand, i.e. the church. In this present government or the present administration, where you talk about state and federal, there's a separation of church and state, contrast or versus what we call a fusion of power. All right? There's a separation of church and state versus church state. Once again, a separation of church and state versus church state. Under a fusion of power on the church state, it's called king and parliament. Under separation of power, i.e., just a state contrast to a church, is under what we call the authority of what we call the executive branch. All right? It's under the authority of the executive branch, which we'll go into in a second. Before this act, vast tracts of land were left directly to the church, which never relinquished it. This goes back to the English Reformation under the Henry VIII of the House of Tudors. All right, very important. Who are the key players in this particular claim? Before this act, vast tracts of land were left directly to the church, but never relinquished it. Why? Because it's perpetual. Other land could be transferred to anyone under what we call common recovery. Inherited only through a family line, sometimes only through the male line, agnatic succession, or revert to an overlord or the crown upon the death of a tenant. This is a result of what we call escheat as a result of interstate. Church land had been a source of contention between the crown and the church for centuries. Did you hear that? The crown and the church for centuries. We know the English church represents the crown. So if there's a conflict between the crown, which is the English Church of England, then the church who claimed to have the authority of the crown is the Roman Catholic Church, which was at that time under the authority of the monarch of King Henry VIII, who was a Roman Catholic until the reformation of the church when they broke away from the Roman Catholic Church under the archdiocese or the archbishop, going back to St. Augustine of Canterbury, which had all the Anglo-Saxons converted to Anglo-Saxon in 597 under the authority of Pope Gregory I, all right, who influenced the so-called Vikings, which we know as the Northmen, which consist of what we call the Frankish, the Visigoths, as well as the Lombardians, all right? These are all descendants of the Capetine dynasties, who are descended from the Merovingians, who are descendants of the Carolingians, who never claimed to be descendants of gods like the Anglo-Saxons. All right? Like the Anglo-Saxons. Let's move forward. I have to continue to narrate. All right. In the opinion of William Holdsworth, all right, quoting such scholars as Gilbert Sanders, Blackstone, Spence, and Digby, that septuagint in English law had a Roman origin. An analogy exists between septuagint use and usufruct or the bequest of fideicommissium. If I'm pronouncing that wrong, forgive me. These are intended to create a fiefment to one person for the use of another, all right, i.e. beneficiary. Gilbert writes, also seen in Blackstone's, that they answer more to the fideicommissium than the usufructus of the civil law. These were transplanted into England from Roman law about the close of the reign of Edward III of England by means of the foreign ecclesiastics who introduced them to invade the Statutes or Mortmain. Okay, the Statutes or Mortmain was passed by Edward I. Edward I was the son of Henry III, the son of John, the son of Henry II, son of Godfrey V, kind of grand Jew. All right, but key note, in the opinion of William Holsworth, who was a legal historian and a Venerian professor of English law at Oxford University, which was established in the 10th century or 11th century by Henry II. All right, Oxford University. All right, this is the same profession that William Blackstone was associated with as a Venerian profession. All right, which is William Holsworth and Blackstone is going to be referred to in case law that I'm going to show you in a second, in modern day case law from either the state of New Jersey or from the federal government, all right, as well as from other states, all right. I'm not sure which case William Holsworth was made reference to, but I have it here, so we'll get to it in a second. Medieval inventions, very important. The origin of the successor trust or fiefment. Now, common covering is the practice which America follows now in what we call now fee and simple. Fee and simple is the result of common recovery, which was created by what we call attorneys. Everybody write that word down. Common recovery. Common recovery. The reasons have been given for the invention of the successor use as a legal device during the Crusades and other wars on the continent. Landowners might be gone for long periods of time. Others might be absent because of adventures of religious pilgrimage. All right. There were no assurances that they would ever return home. The successor use allowed them to leave a trusted friend, a relative with the sort of powers, discretion, and they hope the duties. Today, these powers would be called the power of attorney. You hear that? Religious orders such as the Franciscans, Cistercians, Benedictines, and other mendicant orders took vows of poverty, yet retained the use of donated property. The successor use allowed them to benefit of land without legal ownership. All right. So as we can see under common recovery, which I'll show you in the present statute in a second, this is how they usurp by way of modern day trust law, all right, or what we call corporate trust law, which involves what we call a will or a testament, a last will and testament, all right, a last will and testament. Our ancestors didn't have or leave last will and testament because our estates transferred by what we call operation of law via statutory law, okay, via statutory law. Title 46, New Jersey Revised Statute, possession or property, which denotes to ownership. All right? Ownership. Somebody needs to show you valid precedents to support any claim in regards to some type of interest in some such quay. All right? Especially when it involves church property. Because the United States and the states are overseers or what we call trustees of church property, C-16-1-28 of New Jersey Revised Statutes. Right stated in the Charter of Great Britain, safe from repeal. And Act 2 incorporates trustees of religious societies for property held in corporations in place thereof. That's a statute, i.e. operation of law. All right? That's how disposition of property in regards of inheritance is transferred. All right, not by leaving it by some last will and testament, because those falls into what we call fiefments. All right, either fee and simple, fee and life estates, fee and simple, or what is it? The feasible life, if that's the term. I might have it wrong, so don't quote me. Let's move forward. Besides the obvious limitations placed on successor by the statutes of Mortmain, The statute of uses and the statute of wills its legality was shaped indirectly by the provisions within the Magna Carta and Quid Imperatoris. All right, we know the Magna Carta goes back to John, son of Henry II, son of Godfrey. He was called John of Rudiment. All right, and we know Quid Imperatoris was a result of John's son, Henry III, because Edward I was a son of Edward III. And then the statute of uses and the statute of wills were created by Henry VIII through the English Reformation. He was from the cadet branch of the Lancaster branch that was shaped by the House of Lancaster. All right, under Edward I. Besides the obvious limitation placed on the cestui fiefment, i.e., trust for the beneficiary, this is by the statute of mortmain, which means stead pledge. Statute of mortmain means a dead pledge. The United States are subject to the statute of mortmain, which in their case will be the Articles of Confederation, because under Article 6 of that Constitution of this modern day, 1789, it clearly says all that engaged in prior to the adoption of the Constitution to remain in effect as in pursuance to the Articles of Confederation, because under the engagement clause, the United States pledged themselves. The United States has pledged themselves. All right? What is the statute of uses? We're going to visit that real quick before we move forward. So the statute of mortmain was passed in 1290, right? 1290 was the same time you had the Scottish independence from the Plantagenet King Edward I. Did you understand what I'm talking about? The Scottish independence took place in 1290 as a result of Edward I becoming king of the Scottish territory. Statute of uses. Statute of Uses by Henry VIII was an act of Parliament of England that restricted the application of uses in English property law. The statute ended the practice of creating uses in real property by changing purely equitable title, i.e., this is done by the Chancery Court, i.e., the King's Court, all right, in lieu of what we call equity, all right? It says changing the purely equitable title of beneficiaries of use into absolute ownership with the right of seizure, i.e., the right of possession. All right, we see that. That's the statute of uses. What's the statutes of wills? Everybody click that. Give me a second. I'm back. Before I continue, I want to give a shout out to my brother Willie Jefferson. We call him Syph, Big Syph, Syph of Love, for his remarkable recovery. I had him on one of the podcasts in regards to him giving his testimony of his road to recovery. He's doing very well. All right, so I want to shout him out. He's watched his lesson. He's a Jefferson. You know what I'm saying? So it's very important you understand his origin, his descent, his family bloodline, which goes back to the Plantagenet crown because Jefferson is Godfrey, and Godfrey, where the surname originated from, goes back to the origin of where the Plantagenet was established under Godfrey the Fifth Calabrian Jew, who was a son of folk, the ruler of Jerusalem, where we all the children are. We know Jerusalem means city of peace, and we know who controlled the city of peace, the king of peace. And that's no other than King Edgar the Peaceful, because he was called King Edgar the Peaceful, which in our understanding as the martyrs and saints, he was in true indeed Jesus Christ. All right. So the Statutes of Wales, or Wales Act of 1540 under Henry VIII. All right. He was the King of England who got his authority as a result of the War of the Roses and the 100-Year War that took place between the Yorks and the Lancasters. All right. The Yorks and the Lancasters. All right. And we know that uh, uh, Henry VIII had alliances with the Scottish kings. Yes, he had alliances with the Scottish kings. Look under what we call the Treaty of Perpetual Peace of 1503 and the Treaty of Perpetual Peace of 1534. Everyone looked that up, but we know that the Scottish independence didn't gain their independence till 1290. All right, till 1290. And prior to that independence, they were under what we call the Old Alliance, and the Old Alliance was with the Frankish kings who were warring with the kings of England, i.e. the Plantagenet crown. All right, where our family surname descended down from. So it's very vital that we, as Jeffersons, who descended from the Jefferson surname, bearing this title of nobility, understand this history because this is where your estate comes into play, i.e., your right to the land, the right to be here on this land, the right of reversion in uh, uh, what's called the right of reversion of estate in your favor. This is what I come to prove. The Statute of Wills or the Wills of Act was an act of Parliament of England. It made it possible for the first time in post-conquest in English history for landowners to determine who would inherit their land upon their death by permitting devise by will. Prior to the enactment of the statute, land could be passed by descent only if and when the landowner had a competent living relative who surviving him, and it was subject to the rules of primogeniture, the firstborn. And I'm a firstborn, I might add. When a landowner dies without any living relative, his land would escheat to the crown. Did you hear what I'm saying? The statute was something of a political compromise between Henry VIII and English landowners who were growing increasingly frustrated with the primogeniture and the royal control of the land. So as we can see, Achilles says that the land must go to the firstborn, and if there was no firstborn, i.e. no heirs, then it would escheat to the crown. All right? It would escheat to the crown. Let's validate that right quick in our modern day presidents. All right? Modern day presidents. This is the state of New Jersey, represented by the Attorney General, against Standard Oil Company, and the Standard Oil Company in this argument was argued by the Supreme Court of New Jersey. Supreme Court of New Jersey in 1950. All right, in 1950. Now look what the case is saying in 1950, and they're going to mention William Blackstone. Okay, William Blackstone. Look at the verbiage in regards to its treatment, since they just said under or the statute of will, right? It just said under statute of will that if there is no heir, the land escheats to the crown. When a landholder dies without any living relative, i.e. heir, his land will escheat to the crown. All right? We see it right there, black and white. Let's go to a modern day case law, 1950, to qualify that. All right? Since we know that corporations have taken over. All right? It says in regards to In modern usage, escheat signifies the falling of property to the sovereign for want of an owner. And this category embraces not only property which has no other owner, but also property whose owner or whose owners' whereabouts is unknown. My brothers and sisters, I'm talking about my immediate family and those who are part of the English family. Y'all better be listening to what I'm telling you. Under the common law of England, estates came to be classified as another branch of the king's ordinary revenue. This is a 1950 case, y'all. A 1950 case in New Jersey. All right? New Jersey against a Standard Oil company by one of the richest persons in what we call North America, the Rockefellers. All right? The Rockefellers. Under the common law of England, escheats came to be classified as another branch of the king's ordinary revenue, i.e. the king's debt. Blackstone commentary, what was originally an incident of tenure, i.e. feudal tenure, is now an incident of sovereignty, because feudal tenure fall under what we call I lost my train of thought. Feudal tenure is what we call fee simple, and fee simple, i.e., feudal tenure, goes back to the Norman conquest, because those are where the origin of feudal tenure laws originated from. Because we know feudal tenure deals with issuing of parcels of a land, a parcel of a land, what you want to call it, parcel or partial. Deals with parcels of the land. It's not dealing with the whole land, i.e. allodial land, but it's dealing with parcels of a land, or i.e. divvying out the land by way of a land deed. All right? A land deed is called a letter patent or a fiefman, which is a trust, i.e. cess du cre, for an heir. But if it's not given to an heir, then that means that the land has succeeded. And if it's not given to the crown, then that means that it has fallen under what we call bona vacatina, which is abandoned property, which comes under the authority of what you call the state. Because the states took over the authority of the crown by way of the surrender of the power of the crown under king and parliament by way of the Articles of Confederation, which I'll show you in a second. It says here, Blackstone was originally an instance of tenure and now an instance of sovereignty. The doctrine of escheat at the early common law operative only upon that which was a subject of tenure, since related to the reversionary right of the lord to take for want of a tenant, was eventually extended to include personal property, tangible and intangible. All right? Tangible and intangible. All right? So we call intangible property, what's that term? Intellectual property. All right? Intellectual property. The principle was that the right to take that which belonged to no one pertained to the crown as jura regalia. All right? The crown stepped in to take the property because it is vacant. Property described as bona vacatina, i.e. abandoned property, is taken or assumed by the state as its own. Property of this class falls to the crown as a matter of right and the exercise of its sovereign power. In personal estates, which are allodial by law, the king is last heir where no kin. Did you hear me? The king is last heir when there is no kin. All right, so the only person that can claim the inheritance, i.e. the estate that was left for the beneficiaries, is the king, because the heirs have been disqualified as a result of the national standards of the national people are not here or not being practiced. We must understand what's going on. So we have a 1950 case by the Standard Oil Company represented by the Attorney General, and they are referencing the kings of England. They're referencing, as we said, the authority as established under the authority of what we call the crown, because the crown, as we just read here, deals with escheatment. That's the concept of the crown. That when there is no heir, it escheats to the king who represents the crown as what we call corporation sole, because we know that under the statutes of mortmain, the land under the statute of mortmain remains an entail. That's why it's called crown land. That's why it's called crown land. All right, let's move forward. I don't want to miss nothing. All right. So it says, going back to the Sestuque, besides the obvious imitation placed on the Sestuque by the statues of Mortimer by Edward I, all right? Edward I of the Plantagenet crown, all right? Son of Henry III, all right? The statute of uses by Henry VIII and the statute of wills by Henry VIII its legality was shaped indirectly by the provisions within the Magna Carta, all right? And the Queen Imperatrix. The Magna Carta was created by John, the son of Henry II, son of Godfrey V, Count of Anjou, where our family name descend now from, but also Queen Imperatrix. Queen Imperatrix was a law passed by who? Edward I. At the same time, the Jews gained their independence in 1290 as a result of them warring with who? Edward I. Let's see Queen Imperatrix. You know I'm telling the truth, go look at the shell. Got that 3 lions. All right. Queen Imperatrix is a statute passed by the Parliament of England in 1290 during the reign of Edward I that prevents tenants from alienating their lands to others by what we call subinfeudation. Subinfeudation results from common recovery. Instead, requiring all tenants who wish to alienate their land to do so by substitution. All right, this is fee and simple. The statute, along with its companion statute, Quo Warranto, which is a royal prerogative, which is a writ. All right, Quo Warranto means it's order to show cause. All right, a Quo Warranto is an order to show cause. Also passed in 1290, I Quo Warranto, was intended to remedy land ownership disputes and consequent financial difficulty. To remedy land ownership disputes and consequent financial difficulties that have resulted from the decline of the traditional feudal system. In England, during the High Middle Ages, the name Queen Imperatrix derived from the first 2 words of the statute in the original medieval Latin, which can be translated as because the buyer. Its long title is a statute of our Lord the King concerning selling and buying of land. It also cited as the statute of Westminster III of many English and British statutes with that title. Okay? So it said a statue of the Lord and King, all right, in regards to Queen Imperatrix, which means that you cannot alienate land. All right. Why? Because the land is inalienable. If it's inalienable, that means it's allodial. You can't sell it. All right. So if it's established by, as it says, the Lord Kings concerning selling by land, also cited in the Statute of Westminster, then that means that this is the Statute of Westminster right here. New Jersey Revised Statute, Title 46, 2021, Alienation of Freehold Statute, Queen Imperatrix, Tehran. From and after March 18th, 1795. All right, 795. Any freeholder, i.e., those holding the fee and simple, may give, sell, or alien the real estate whereof he is, or at any time sell, shall be seized in fee and simple, or any part thereof at his pleasure, and such donee, purchaser, or alienee shall hold the same free of anything or service to the donor, seller, or alienator. Why is this the case? Let's see. 2021 statute, New Jersey by statute. From after June 12, 1795, no fine or common recovery that has or shall be entered, made, had, or suffered in any court record of the state shall operate or construe to be a conveyance or assurance of real estate. So whatever deeds you have in your possession right now in regards to some easement by or what we call a possessory right or use, which is also called an easement by way of encumbrances that was subject to the state's police powers, that means that you don't actually own it. You just got the right of use. All right? So it clearly says here, it says, no fine or common recovery that has been or shall be entered, made, or has suffered in any court of record of the state shall operate or can be construed to be a conveyance or assurance of any real estate, or in any way bar a issue of entail. Did you hear that? Or the reversion or remandment of their lawful claims and entries, any usage or custom to the contrary, and any wise notwithstanding. So if it's not entail, because the only highest form of ownership in North America is fee simple, fee indefeasible, or life estates, and which is resulted from common recovery by way of what we call power of attorneys. All right? Power of attorneys. We see here that under the statute, that particular type of fee and simple interest in some type of estate, i.e. land, has been abolished. Why is this the case? Let's see why. I don't know why we don't read. All gift grants or conveyances made prior to July 4th, 1776, their Declaration of Independence. Keep that in mind because see where I'm going with this. As of 1776 of any state of inheritance by a letter patent, i.e. a charter. You hear what I'm saying? Any inheritance by way of a letter patent, i.e. any fiefment, any deed, any interest in regard to the right of possession of use is void. Why? Because under the great seal of this state or any state within this union or any state under the federal government as a result of the Articles of Confederation, it clearly states here that or any other manner by the state, by the legislature thereof, or by the commissioners or agents of forfeited the state, or by the lawful competent authority under the state, shall be and remain allodial, and no feudal and not feudal, and shall forever be and continue in free pure allodium only, forever discharged of all feudal tenures and the interests thereof and all other services whatsoever. Okay? Very important. I'm going to read it again without any interruptions. All gift grants or conveyances made prior to July 4th, 1776 of any estate of inheritance by a letter patent under the great seal of the state or in any other manner by the state, by the legislature thereof, or by the commissioners or agents of forfeited estates, or by other lawful competent authority under the state, shall be and remain allodial, and not feudal, and shall forever be and continue in free pure allodium only, forever discharged of all feudal tenures of mistresses thereof, and all other services whatsoever. Why? Let's see why. I've shown this many times, but I said I have to continue to reiterate so that when you continue to watch these lectures and videos, and based off your reviewing what you've been taught, that as you go back through it, you'll be able to start the process of elimination of what you thought was the truth and what you now see presented before you as being the whole truth, nothing but the truth, so hopefully God. So as you can see here, this is concrete, not abstract. I'm showing you proof. It says here, all tenures. Make sure you see this. (2021) certain tenures and holdings turn into free and common soakage. The tenures of honors, manors, lands, tenements, or hereditaments, or of estates of inheritance at the common law, held either of the King of England. The King of England holds the office, all right? Whether de jure or de facto, he owes the office as a corporation sole, right? But we know a corporation sole is a natural person. So if the natural person holding the office as the king is not perceived as a natural person, then he's a corporate aggregate. And we know that under the United Kingdom, under their parliament is subject to what we call the Roman Catholic Church. All right, because the Roman Catholic Church initiates the coronation for the United Kingdom and the monarchy there, right, which does not operate and function under what we call the Kingdom of England, because the Kingdom of England, the Kingdom of Ireland, and the Kingdom of Scotland are separate parliaments. All right, are separate parliaments. So it says that the tenures of honors, nobility, the manors of lands associated with that title of nobility, the tenements or hereditaments or of estates of inheritance at the common law held either of the King of England or of any other person or body of politics or corporate at any time before July 4th, 1776, and declared by Section 3 of an act entitled An Act Concerning Tenure, passed February 18th, 1795, to be turned in holdings to free and common soakage from the time of their creation, and forever thereafter should continue to be held in free and common soakage, discharged of all tenures, charges, and instances enumerated in said Section 3. Why? Because the land is allodial, as required because the land is entailed, as required by the statutes, wills, and statutes of use at the statute by Henry VIII, going all the way back to the Magna Carta and Queen of Pretorius as established by King Edward I. All right, that's why when the statutes were transferred under the crown, under the Parliament of England, to what we call the electoral college, that was created under the states and the federal government, that power was transferred to them as sovereign power or sovereignty, okay, as what they call sovereignty. But that sovereignty was limited because that actual power that they had was the parliament rightfully belonging to the king in parliament. So in order to take that power from king in parliament, they had to remove the power of authority from king in parliament, which is a fusion of government between the executive and legislative branch. They had to separate the executive and legislative branch. All right, and had the legislative branch subject to the executive branch, which is a violation of law because too much power in the hands of any one branch of government is tyranny. It's tyranny. All right, we must understand this. So it says the King of England or any other person or body politics. You're talking about king and parliament. This is the legislative council. All right. This is the legislative council of king and parliament that operates under what they call royal prerogatives. Royal prerogatives, and the royal prerogatives of the council of the king is under the authority of what we call the king's bench. All right, which is responsible for what we call the judiciary. Courts of common pleas, courts of equity and chancery, courts of exchequer. All right, courts of orphans. All right, courts of errors and appeals. All right, there were many sections of the king's bench. Why? Because the king's government was an itinerant government. It was a moving government. We know it's a moving government because we can find the king's government here in what we call New Jersey under what we call New Jersey Provincial Council, which was at that time under the authority of the crown, which was perpetual. It's indefinite. It has no beginning and end. Why? Because of what the legal term or the Latin term rex non-quantum, what's it called? Rex non-quantum mortier. if I'm saying it right. Rex NUNQUAM mortier. The king never dies. The king never dies as a result of the demise of the crown. The demise of the crown is the transfer of the crown power as a result of the incorporation or the personification or the incarnation in the abstract realm of the King of England and the responsibility of the king to the body of politics, i.e. the legislature, which was a fusion of power under the royal prerogatives under the crown. Okay? Let's get to it. We know the Magna Carta. We know that the Septuagint in regards to the fusion of power that was under the authority of the English Church of England, known as the Crown, under the authority of the corporation soul, which was the incarnation or the personification or the incorporation of a natural person into the office of what we call the English, to what we call the English throne. All right, the English throne, because that goes all the way back to what we call the Norman Conquest, because the result of the Norman Conquest was a result and fight over the English throne. It went from the Norman Conquest to what we call the War of the Roses, which resulted in the English Civil War. Resulted in the English Civil War. I closed that gap, but we're going to close it again. All right, let's move forward. The Norman Conquest. It's where feudal tenure was established. Right here. William the Conqueror claim to the English throne derived from the familial relationship with the childish Anglo-Saxon king, Edward the Confessor, all right, who may have encouraged William's hopes for the throne. All right, you see it right there. Everybody's seeing it for themselves. Although William's main rivals were gone, he still faced rebellion over the following years and was not secure on the English throne until 1072. The lands of the resisting English elite were confiscated. Some of the elites fled into exile. All right. To control his new kingdom, William granted lands to his followers and built castles commanding military strong points throughout the land. The Domesday Book, a manuscript record of great survey of much of England and parts of Wales, was completed by 1086. Other effects of the conquest included courts and government, the introduction of Norman languages as the language of the elite, and changes in the composition of the upper class and William enfeoffment lands to be held directly from the king. More gradual changes affected the agricultural class in the village life, and main changes appears to have been the formal elimination of slavery, which may or may not have been linked to the invasion. There was little alteration in the structure of government as the new Norman administration took over many of the forms of Anglo-Saxon government. Did you hear that? Of Anglo-Saxon government. Very, 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 very important to understand that. All right. Why do I say that? Rex NUNQUAM mortier. The king never dies. The demise of the crown is the legal term in the United Kingdom and the Commonwealth for the transfer of the crown upon the death or the abdication of the monarch. So when you say the crown, you're saying the English throne. We know the crown is a corporation soul, which consists of a natural person. All these stories are going back to William the Conqueror. We don't know if they existed or not, because in the Middle Ages, they were considered to be what we call legends, myths, or folklore. You know what I'm saying? So based off those legends, myths, and folklore, which is the majority of people who claim to have an inheritance, is based off myth, folklore, or myth, folklore, or legends. Can't prove anything in regards to them being these type of people in this present day. But I'm showing you in the present day administrative laws known as statute that were instilled in statute originated from the original promulgation of the legislative authority going back to the legislative council of the days of the king and parliament, and this present day going back to what we call time immemorial under the authority of the crown. Apparently it must have been natural people, because their writings, their law, their authority, their presidents still exist today, and I'm showing you right here. All right. The crown transfer automatically to the monarch's heir by way of inheritance. All right. As we read in Standard Oil Company represented by Attorney General Parson versus the Standard Oil Company represented by the Attorney General representing the state versus the Standard Oil Company owned by the Rockefellers in regards to abandoned property as a result of them being no heirs, which automatically streets to the crown. All right. And this case was in 1950 in regards to property belonging to the crown. All right. That can only be gained back from the king, because it said when there is no heir, when it says, let's just go to it and prove it. 1950 case. The doctrine of the street as the early common law operative only upon that which was the subject of tenure. We know William the Conqueror established feudal tenure, since it relates to the reversionary rights of the lord to take for one of a tenant, was eventually extended to include personal property, tangible and intangible. The principle was the right to take that which belonged to no one appertaining to the crown, as is jure regalia. So this is a 1950 case, make a reference to the time going back to William the Conqueror, when the institution of feudal tenure or feudal law in regards to some type of inheritance, which was left for heirs, and if there was no heirs in regards to that inheritance, known as a cess-2k for beneficiary, then it must have ceased to the crown from back then till the present day, 1950. All right, who can produce precedents, facts like that? All right. The crown steps in to take property because it is vacant. Property described as bona vacantia is taken or assumed by the state as its own. Property of this class falls to the crown as a matter of right in the exercise of its sovereign power. All right. And personal estates which are elodial by law, the king is last heir when there is no kin. I already showed you the statutory law that the land under Title 46 was elodial, going all the way back to the charters of Charles II and to Duke of York. You don't believe me? Let's go right here. (2021) statute. Feudal tenures are abolished. The feudal tenure estates and the instance thereof taken away, discharged, and abolished from after March 12, 1664. This is 1664 under the what we call the Kingdom of Great Britain. All right, under the Great Britain, British Empire. The Kingdom of Great Britain and the British Empire existed simultaneously. All right. And we've seen this right here in the 23 statute. Even though the statute is 2022, 21, we're in 2023. All right. And it says the federal tenures going back to 1664 that were given by Charles II, the Duke of York, which was a charter given to George Coleridge and John Berkeley under their constitution called the Concession Agreement, which was surrendered back to the Crown in 1702 under what we call New Jersey Provincial Council under the province of New Jersey going back to 1664. All right? Back to 1664. How we know that? Let's prove it. We just read their statutory law. Now we're going into the what we call their what we call the congressional assembly, their congressional assembly, which is called their government, which consists of an upper house and a lower house, which in New Jersey is called the upper house and general assembly, and the federal government is called the Senate and the House of Representatives. All right, we know the House of Representatives and the General Assembly, as well as the state Senate and the part itself, the Senate and the House of Representatives for the federal government, as well as the Senate and the General Assembly for the state's government of New Jersey, are subject to the authority of what we call the king in Parliament. How we know that? Because in Ward versus Kingdom, the court ruled that the Constitution of 1776, the Constitution of 1844, which was modeled largely after the 1789 Constitution of the United States, as well as the Constitution of 1947, all adopted the common law of England. All right? And we're going to read it in a second, so I won't be parakeet. All right? New Jersey Provincial Council. The New Jersey Provincial Council was the upper house of New Jersey legislature under colonial rule until it was replaced by the New Jersey Legislative Council under New Jersey Constitution of 1776. You see here, it says the crown. So if it's the crown, that means the English throne was governing here and was governing these territories going all the way back to the Norman conquest, because the statutory law governed under Title 46 deals with tenures that said right now, under the tenure laws, under that statute, that the land was allodial. That the land was allodial. And that no common recovery can stop a claim that's entail. And we know crown land is entail. Why? Because it's inheritable. All right. So under the provincial council, that was the crown. The provincial council was established in 1702 upon the surrender by the proprietors of East Jersey and of West Jersey of the right of government of Queen Anne. Did you hear that? Which united the two colonies of the province of New Jersey, which as a world colony, and established a new system of government. The instructions from Queen Anne to Viscount Cornbury, the first world governor of New Jersey, outlined, did y'all hear me? Outlined a fusion of power system which allowed for an overlap of the executive, legislative, and judicial authority, and provided for a bicameral legislature consisting of a council and general assembly. So the federal government is not even in existence right now, such as the Senate and the House of Representatives. It's just the general assembly and the council and our council, and the council represents the Senate because that's a legislative council, and the legislative council functions on what we call the royal prerogatives of the crown. Why? Because it was called king and parliament under the fusion of power, as you see here. You didn't get the break away from the fusion of power until what they call the separation of till they got to what they call the separation of powers that dealt with the separation of the executive, legislative, and judicial branch. All right, you must understand this. The crown, key figure. So it says, a system which allowed for overlap executive, legislative, and judicial authority and provided for a bicameral legislature consisting of a council and general assembly. All right. So, and it said that they surrendered their power to the crown. The type of it was the upper house of the New Jersey legislature, which means it was the House of Lords, not the House of Commons. You didn't get the House of Commons until you got to the colonies. All right. The lower house, i.e., the House of Burghers. All right. That was the lower house. The House of Commons, now called the General Assembly. Let's understand what's going on here. So let's revisit from the previous lessons. So what is the Legislative Council? A legislative council is a legislator or one of the legislative chambers of a nation, colony, or subnational division, such as a province or state. We know that New Jersey Provincial Council under within the province of New Jersey was under the Parliament of England, which was under the authority or governed under what we call the Crown. Okay, all right. Before they broke away under the Declaration of Independence in 1776, July 4th. All right. Just because you declare your independence, that don't mean you was independent, because the statute said, even though you declared independence on January 4th, 1776, the land still remained allodial. Revised Statute 46:3-6. All right? So it says here, in the United States, a legislative council has a different connotation than a legislative council denoting to a legislative chamber, nation, colony, or subnation division, such as a province or a state. It said the connotation denoting to that which of the United States, it means a council within a legislator which supervises nonpartisan support staff. All right? What's the history of a legislative council contrast to that of a council? Okay? There's a difference. In the British Empire or the English Empire, because the British usurped the power of what we call the English Empire as a result of having de facto officers sitting in office, all right, i.e., sitting as representatives of the crown. In British Empire, the authority under which legislative councils have been constituted has varied, some under royal prerogatives, others by acts of parliament. Now you're getting into the English and Civil War, which was a war between the king and parliament. All right, the English Civil War resulted from the War of the Three Kingdoms: England, Ireland, and Scotland. Everybody do their research on that. Particularly unicameral, which means one house, versus or contrast to bicameral, which means two houses. Particularly unicameral or the upper house and a bicameral legislator, where traditionally many members were appointed by the governor and then say nothing about no president, all right, rather than elected, were given a designation of legislative council. All right, we must understand the difference between a legislative council and a council, because a legislative council functions off the royal prerogatives, and council members function off what we call statutory law, which is known as what we call positive law. Positive law is contrast to natural law, and natural law is denotes to ecclesiastical law, not abstract though, concrete. So if you want abstract, you can go to the Roman Catholic Church. You want concrete, you have to go to the English Church, because their kings were natural. The Roman Catholic Church kings, i.e., were abstract, i.e., fiction, i.e., spooks. All right. In British Empire, the authority under which legislative council have been constituted had varied, some under royal prerogatives, others by parliament, and some by commission and royal instructions, i.e., by letter patent, i.e., by charters, i.e., fiefment. Why? Because it was associated with the trust that was associated with the beneficiary as a result of it being entail, and it transferred or operated by what we call operation of law. As I just showed you, statutory law of descent and disputation. That's what it's called. All right. So if we understand that our true legislative council functions under what they call royal prerogatives, contrasted of a council who mimics the actions of a de jure legislative council, which is going to bring into questions when we deal with this court case called John versus John, I think it's Johnson and Freeman, which was a case passed in Oklahoma by the Oklahoma Supreme Court in regards to questioning um, uh, 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 the it was questioning those who are in the authority in lieu of what we call House of Representatives, do what we call right of suffrage. Everyone has the right of suffrage to question their representatives. All right, because as the founding father says, there was supposed to be a uniformity in taxation and uniformity and procedural equality, but there was none under the British Crown because of their conflict with taxation and what they say: no taxation without representation. All right, because the representation that they were receiving in regard to the taxation, they deemed as unjust. Okay, so what is royal prerogatives? Everybody hold their thought. Okay, I'm back. The royal prerogatives. The royal prerogative is a body of customary authority, privilege, and immunity recognized in common law and sometimes in civil law jurisdiction possessing a monarchy. These is called the king's jure regalia. All right? The king's jure regalia, as belonging to the sovereign, in which he had become widely vested in the government. It is a means by which some of the executive powers of government possessed by and invested in the monarch with regards to the process of governance of the state are carried out, i.e., fusion of power. We understand that? Fusion of power. We see that fusion of power of the king as the sovereign under the king and parliament, under the king and his legislative council, contrast to that which is being practiced here under the United States, under their federal government, with Congress consisting of what we call the Senate and the House of Representatives, under the authority of the executive branch as a result of the separation of powers. All right, because we know that the vice president controls the Senate, and the House Speaker of the House of Representatives controls the House of Representatives. All right, and they are both is subordinate to the executive branch, which is subject to what we call the electoral college. All right, but how could the executive branch, which is composed of the electoral college headed by the president, vice president, secretary of state, as well as the speaker of the House, how could there be there be subordinate to these executive officers when Article 1 and Article 2 and Article 3 of the Constitution shows a separation of power? It shows a separation of power. All three cabinets are in different uh territories. You got the capital is where your House of Representatives and your Senate sits. The executive branch, where the president and the vice president and the secretary of state or foreign or minister of what's called the secretary of foreign minister sits is he sits in what we call um United States Department of State, which is three different departments, three different territorial where the three different departments sits. The White House, the Capitol, and the United States Department of State. Under the Senate and the House of Representatives, the president and the vice president and the secretary of state, as well as the House Speaker of the House Speaker or the president of the House of Representatives reports to. All right, how we know that? Because they no longer function under the Constitution anymore. They are functioning under statutory law, statutes at large, as well as United States codes. And United States codes and statutes at large are overseen by the House Speaker. The new House Speaker is Mike Johnson. All statutes promulgated are overseen by what we call the United States Law Review Commission. All right? And once the Law Review Commission, they're sent to the Judiciary Commission of the United States. So that means that the executive branch under the Speaker of the House, Mike Johnson, is responsible for not just the creation of the law, but the upholding of the laws. All right? We must understand what's going on. These officers have gone rogue. They have abandoned the royal prerogatives that was established in the legislative branch and their original constitution, going back to the original founding of that society who established the Constitution, going all the way back to the original government under the crown. Because the proprietors are here before the 13 colonies, because they were the ones who allowed the 13 colonies to come here by the letter patents given to them, which is nothing more than charters, i.e. fiefdoms. All right? Understand the game that's being played here. That takes me to United States Fidelity versus Carter, which I already talked about. United States Fidelity Company versus Carter. Corporations we're talking about, all right? (1933) case making reference to the common law of England and the prerogatives or the royal prerogatives of the king and parliament in 1933 in Virginia. In Virginia, which was one of the first settlements here under the de facto kings sitting in the office of the as corporation sole. All right, but in disguise are corporate aggregates. All right, under the office of the Roman Catholic Church. One states that the preferences, common law, and prerogatives of the king. From a very early time, the common law of England gave, or rather recognized, the king's assertion of a right by prerogatives to have a debt due to him by one of his subjects. All right, paid in preference to a debt due by his debtor to one of his subjects. You hear that? This right existed regardless of the solvency or insolvency of the king's debtor, and it was not limited to the collection of taxes, duties, and other public revenues. We must understand the royal prerogatives because everything denotes to the exchequer, the king's debt, the king's monetary, the king's money. All right? Because the king's money funds the kingdom. All right? And protects his subjects. Let's move forward. So I just showed you this case to show that the king prerogatives under the royal prerogatives of the king and parliament is still active and in the present administration. Let's go here. All right, let's go back into where I want to go. I want to go right here. So we're talking about the right of inheritance and the right of that inheritance, it being land, and the land being retained by the grantor. And in our eyes, as English, the grantor of the land was the king. All right. So all those who over here claim to have an inheritance, some type of land, i.e., called real estate, then who is the grantor? You know what I'm saying? Because we know that, as we see, as stated in the case, that all the land given to the proprietors as established by New Jersey revised statutes under Charles II, who was a de facto king of England, as well as going all the way up to King Anne. All the land belonging to these de facto rulers of the King of England sitting on the English throne were de facto rulers sitting on the office. All right? And all the royal prerogatives that they have was surrendered back to the crown, because the crown is perpetual. All right? The crown is perpetual. We see it still existed here in present day as established by present modern day presidents, i.e., case law, which I'm reading to you. All right, so let's go to another modern day president. Since we're dealing with the Legislative Council, which is the House of Representatives, and the what we call either the Senate or the House of Representatives, or prior to them will be the Senate and the General Assembly under authority of the governor. All right, governed by the state's constitution, because we know under Articles of Confederation, what the states maintain their sovereignty. The only thing that they gave to the Articles of Confederation was the rights that they recognized that rightfully belonging to king and parliament, which was the royal prerogative that you still see active today. All right, you still see active today. All right, so this case is very important because this case deals with the ability to be able to question those representatives. All right, because that's what the House of Representatives was there for, to represent the people. All right, to represent the people. And they're going to make this argument in regards to Supreme Court of Oklahoma. And we know the territory of Oklahoma was not admitted to the Union until the 19th century. I think it was 1907? Let's see. I can show you better. Let's go here. All right, let's go here. List of the United States by date and admission to the Union. Let's get a syllabus right quick. Because we ain't talking about the colonies, the 13 colonies, right? We know that the Native Americans were here before the 13 colonies, but they still classify as Native Americans. We know Native America was subject to what we call British America, and British America was subject to what we call the British Empire. So America was an empire. Is everybody understand what I'm saying? America was an empire, and before the colonists got here to this empire, they assumed that it was inhabited by what we call Native Americans. And the Native Americans were found on both sides of this territory, which we call North America. All right, and we know that the original Native Americans, assumedly attested by the so-called historians, are supposed to be what we call the 5 civilized tribes. All right, the 5 civilized tribes. All right, so that's what we're going to go into now in this particular part of this lecture. A state of the United States is one of the Oklahoma. Let me point something. A state of the United States is one of the 50 constituent entities that share its sovereignty with the federal government. Did you hear that? Before we do, let's go here. The federal government is what we call the United States government, and the United States government was preceded by the Articles of Confederation. The Articles consciously established a weak central government, affording it only those powers the former colonies had recognized as belonging to king and parliament. The document provided clearly written rules for how the states' league of friendship, known as perpetual union, would be organized. So the only authority that the sovereignty that the states had was the sovereignty that the Articles of Confederation recognized as them being considered the sovereign as a result of the powers that they were given to them by the colonies, that the colonies recognized as belonging to the king and parliament, now surrendered to what we call the Articles of Confederation, which consists of what we call the 13 original states, all right, or the 13 colonies, which brings me here. A state of the United States is one of the 50 constituent entities that share its sovereignty with the federal government. As we just said, the only sovereignty that the state had is the sovereignty that the federal government recognized as them being the true sovereign. That's the central weak government that they talked about under the Articles of Confederation. And the only powers that weak government had was the power that they had as ideal an ideal government that they usurped from the government that was already existing at that time called the crown. They just took the king out of the equation. All right? They took the king out of the equation. Now Americans are citizens, and we know Americans is based upon the allegiance to the government. All right? Americans are based off the allegiance of government, and that allegiance to the government was based off those who paid their allegiance to the government under those deemed citizens under the Naturalization Act of 1790, where it deals with what they call free white persons. Had nothing to do with us, right? It had nothing to do with us associated with genetics and ethnicity associated with a nation or nationality or a country. It only dealt with those people that came from a nation and had a nationality and came here and committed treason entirely by way of abandoning that allegiance to the nation that they come from, such as us, because we originally were English as a result of having these surnames. Americans are citizens of both the federal republic and of the state in which they reside. All right? Due to the shared sovereignty between each state and the federal government under the Articles of Confederation. All right? States are primary subdivisions of the United States. They possess all powers not granted to the federal government, nor prohibited to them by their constitution of their states. All right? Very important. In general, state government has the power to regulate issues of local concern, such as regulating interstate commerce, running elections, creating local government, public school policies, non-federal road constructions, maintenances. Each state has its own constitution grounded in Republican principles, and government consists of executive, legislative, and judicial branch. All right? This is what they call police powers. Under the police powers of the state. All right? Because the police powers originate as a result of interstate when there are no heirs on the land. When there are no heirs on the land, that means that a new sovereign claims the land by either what they call right of discovery, which they assume that's how they acquired the land. But we all know, based off my teaching that I'm teaching you, that it was acquired by right of conquest, as established by Henry VIII, when he conquered the House of Lancaster, which was a cadet branch of the Plantagenet crown, which were the rulers of the territory going all the way back to this hemisphere called the Anglosphere, which is the competent territorial landmass west and east of what we call the English Empire, as well as all the other overseas territories under what we call the radical title of the king. Look those terms up. All right? Let's move forward. The reason why you have more than 13 states is a result of Article 4, Section 3, Clause 1 of the Constitution, which granted Congress the authority to admit new states into the Union. Right? It was unconstitutional for the executive branch to allow states into the Union. All right? Because Article 1 deals with the legislative branch, Article 2 deals with the executive branch, Article 3 deals with the judiciary branch, and Article 4 deals with the allowing for amendments to the union. But who allowed these people to amend the union? The legislature was didn't. It was the executive branch who, through the influence of the what we call over the overseership of the executive branch, i.e. the president, the vice president, which we know under the United States codes controls the Senate and the House of Representatives, who are under control of the vice president and the Speaker of the House. All right? Article 4, Section 3, Clause 1 of the Constitution grants to Congress the authority to admit new states into the Union. Since the establishment of the United States in 1776, the number of states had expanded from the original 13 to 50. Each new state has been admitted under the equal footing with the existing states. This is a violation of Article 6 of the United States Constitution in regards to all debts contracted, because a debt is a tax. The reason why they broke away from Great Britain is the result of the tax and the result of the what we call the unjust and the representation, because they didn't have any representation in the Parliament of England or the Parliament of Great Britain or the Parliament of Scotland. Why? Because you were a slave to them. As you can see, Delaware, Pennsylvania, New Jersey, Georgia, Connecticut, Massachusetts, Maryland, they got 50 states here. All right. As a result of Article 4, Section was Article 4, Section 3, Clause 1. All right. 50 states were mentioned in the Union, where under the Articles of Confederation there were only 13. All right. There were only 13. The Second Continental Congress approved the Articles of Confederation for ratification by the individual states on November 15, 1777. The Articles of Confederation came into force on March 1st, 1789, after being ratified by the 13 states. On March 4th, 1789, the general government under the Articles were replaced with the federal government under the present Constitution. All right? So under the Constitution is null and void as a result of the power that existed before the creation of the Constitution, which was the power of king and parliament and the legislative authority that backed king and parliament. Not under the congressional that was created under that Constitution as established by those individuals that we're talking about now, but the individuals that were here prior to the individuals that were under the authority of king and parliament as its legislative council, functioning under what we call the royal prerogatives of what we call the crown. Okay? Clear, cut, and dry. All right, so we know here there's only original 13 colonies. All right, when you go back to territory dealing with that west of the original 13 colonies, you deal with the territory belonging to what we call France and Spain. All right, which had existed here in what we call North America prior to the British Empire, because the British Empire was the English Empire, and the English Empire had conflict with the kings of France, which was the rulers of the territory west of what we call North America. All right, known as what we call Indian Territory or the Oklahoma Territory. Once again, Indian Territory or the Oklahoma Territory, and this all are associated with what we call the cess2k, or the trust, all in regards to what we call inheritance, which deals with the right to have land. All right? The right to the land. I just proved to you that the land is allodial under the king. The land is allodial, right? And the land is allodial, why? Because it's subject to the empire under the authority of the king. And we know that the king, the English kings, control everything going back to what we call time immemorial. Why? Because I'm going to show you case law making reference to what we call time immemorial. All right. Time immemorial, going back to the kings who existed in what we call time immemorial, because they were the progenitors of those kings when we came down to, when we came to our downfall, when we fell. All right. When the interregnum came about. This is what we need to clear up. This is what the English Third Temple Church is clearing up, because all the property belongs to the church, where everybody claiming to have an interest in, i.e., the land. I ain't talking about the buildings and the fixtures that are attached to the land. I'm talking about the land itself, and not just a parcel of land or a parcel of land or an estate of land that's up to abundant rights. I'm talking about the full control over the land as a result of it being the land subject to the sovereign. That's what I'm talking about. Let's get on with it. We know that your government is controlled by the legislative council, and in this case, as we said, the legislative council is not really legislative council. It's just a council of men, or assembly of men, or assembly of individuals who's come together in what we call an electoral college. All right, this is how they come about, and they function under what they call parliamentary procedures that originated from Parliament. They adopted the rules and regulations and procedures that originated from Parliament and King. Parliament and King. All right. This is Jones versus Freeman, 1944, decided 1944, February 8th. All right, in Oklahoma. All right, Supreme Court, Oklahoma. But first, let's go to Oklahoma. All right, and get a little history of Oklahoma. Right here. The land now known as Oklahoma has been inhabited since at least the Ice Age. Oklahoma means people, red people, basically. Means red people. The southern plain villagers and the Mississippian people inhabited the area between roughly 800 and 1500 AD, and it's the meanest year of our Lord. The Southern Plains Panhandle culture developed in the Oklahoma Panhandle and western Oklahoma, while the Cadone Mississippi culture inhabited the eastern parts of the state and included the major settlement of spiral mounds. The area was also inhabited by Wichita people, Tonquina people, or the Gadar people. This is what the so-called um, uh, people who are assumed to be studying the people who inhabit these particular lands. And I'm letting you know these people were not Native Americans as you see them portrayed today. All right? Let's move further. The first European contact with the region was Spanish explorer Francisco Vasquez de Coronado. All right? In 1541. However, all right, we're not talking about discovery, you coming over here and setting up shop. We're talking about ownership of the land. All right. However, the land was claimed by the Kingdom of France, Louisiana colony, and included in the Louisiana Purchase that was then succeeded to the United States in 1803. Okay, in 1803. Oklahoma was the colony included, Oklahoma was part of the District of Louisiana, Louisiana Territory, Missouri Territory, Arkansas Territory, before finally being designated as Indian Territory. In the 1830s, the United States began forcibly removing Native Americans to Indian Territory, with the most famous instance being the deportation of the 5 civilized tribes, the Cherokee, Chickasaw, Choctaw, Muskogee, and the Seminole, which became known as the Trail of Tears during the American Civil War. All right, so there you have it. All right, and in regard to the inhabitants on this land and the claims they had in lieu of the rights to be on that land, it just said here that the territory was claimed by France under the Kingdom of France. And we know the Kingdom of France was at war with the Kingdom of England as well as prior to which preceded the wars that the United States had as colonies with the British Empire, who subverted or usurped the offices of those who were sitting under the authority of the crown under the English Empire. All right? They usurped it. How? Let's prove it. Let's prove it. Let's go back to the Oklahoma case. All right? Because we know that the Oklahoma now became what they known as Indian territory. All right? And we know case law, Johnson versus McIntosh, as well as Martin versus Waddell, it clearly says in those cases that the Native Indians or American Indians were nothing more than mere occupants of the land. Right? They were nothing more than mere occupants of the land because the land belongs to what? The crown. Why? Because the crown had authority here in North America, which were conflicting with the Frankish rulers going back into what we call the Kingdom of France. All right? The Kingdom of France, and the Kingdom of France was established with the House of Capet, and the House of Capet goes back into the Capetan dynasty. Let's prove it. Kingdom of France. Right here. The Kingdom of France is the historiographical name or umbrella term given to various political entities of France in the medieval and early modern period. It was one of the most powerful states in Europe since high Middle Ages. It was also an early colonial power with colonial colonies in Asia, Africa, and the largest being New France and North America. Did you hear that? All right. And when we're dealing with New France, or the Kingdom of France, you're not talking about the French kings going back to the Plantagenet kings or the Angevin kings or the kings going back to the kings of Anjou. You're talking about those kings going back to what we call the Frankish kings or Franco kings that had what we call the alliances going back to the Order Alliance. All right. The Order Alliance in 1290, I think it was 1296. All right, it says here, France originated in West Francia, the western half of the Carolingian Empire, with the Treaty of Verdun. A branch of the Carolingian dynasty continued to rule until 987, when Hughes Capet was elected king and founded the Capetan dynasty. The Capetan dynasty was one with the Plantagenet dynasty. All right. The Plantagenet dynasty was created by Godfrey the Fifth Count of Anjou, whether Godfrey or Jefferson surname come from, and son is the prefix denoting to come down from. So we are the descendants of the Godfrey's noble family. All right, and the word Godfrey means lords of the earth because the word Frey means Lord and Geo means earth or God. Godfrey, Godfrey, or Godfrey, Geofrey. And then you got son. All right. So y'all can play these games if you want to, but I'm giving you pure facts. The Carolingian dynasties are those who descended down from Clovis the First, and they never claimed to be descendants of gods. They descended from these abstract gods, not the descendants of God who were here on earth, because the people of the Middle Ages were apparently natural people as a result of their laws being still in place in this present day, as shown by your King Clifford Jefferson, and the New Jersey Revised Statutes, originated from the Constitution that originated from the legislature that originated from what we call the Crown in 1702. when it was being usurped by those de facto kings going back to the House of Stuart, which got their authority from the House of Stuart. I mean, House of Handover under Henry VII and Henry VIII, which were rooted in the Lancaster branch, which was established by Edward IV and Henry IV from the House of Yorks and the House of Lancasters, which we are going to go into with this case that we're going to see from the case of Oklahoma, dealing with what was it, Johnson versus Freeman, John versus Freeman, Jones versus Freeman. Forgive me. Everybody take it a second. If you ain't got to pull it up, go ahead and pull it up. What you see here, from 1 to 12, deals with the Oklahoma Constitution. All right? It deals with the Oklahoma Constitution. When you get time, pull up the Oklahoma Constitution and reference that Constitution to this lesson, which I'm going to give to you in regards to this breakdown and reference to what the court says about the ability to be able to check government by way of the king's royal prerogatives, such as the prerogatives writ of circulator, writ of managers, writ of quo warranto, writ of circulator, writ of prohibition, writ of habeas corpus. These were the royal prerogatives that were at the disposal of the crown, i.e. the king, or person, or corporate, or body politics, because that consists of a private person or a private individual that can invoke the prerogatives of the crown as established by Chief Justice Vanderbilt, as he stated in Ward versus Keenan. We'll show you in a second if I get a chance to go to it. All right. But this is Jones versus Freeman, a 1944 case in regards to the state of Oklahoma, which was admitted to the Union in 1901, if I'm not mistaken. All right. Prior to its admission to the Union, it was deemed as Indian territory. And this Indian territory, prior to it being deemed Indian territory, was territory belonging to the Kingdom of France. All right? And the Kingdom of France was under the authority of the king, or the Frankish king, which originated from the House of Capet, which gave birth to the Capetine dynasty, which were all associated with the king or the Frankish kings going back to the Carolingian or the Merovingian dynasty, all originated from King Merodach, which was a descendant of Clovis I, which never claimed to be the descendants of gods like the Anglo-Saxon. All right? Like the Anglo-Saxon kings. All right? And when we say God, we're not talking about an abstract God, because abstract God will be a spook. The ones you see in the Bible, the ones you see written in the King James Bible, written by King James, a Scottish king who got his authority from a Roman Catholic known as Henry VIII. All right? Now, I'm going to show you in this court case, in regards to king and parliament, now known in this present day or this modern day, the Senate and the House of Representatives. All right? The Senate and the House of Representatives, and how to bring the Senate or the House of Representatives or any holder of any offices, and as a result of prerogative right that every subject of the king have in lieu of a petition of right. Every citizen or subject of the king has a right of petition. All right? Has a right of petition. If you don't know what that is, go to Chisholm versus Georgia and United States versus O'Keefe. They all deal with the right of a subject to petition the king in lieu or in seeking remedy under what we call a prerogative writ. Once again, under what we call a prerogative writ. As you can see here, 15. Mandamus. Supreme Court will, in its discretion, refuse to issue writs of mandamus to require elections to be held under apportionment made by the Constitution. Apportionment means sharing. All right. As you can see, we know that just 1 second. Yeah, we know that the cabinet is composed of two houses, the Senate and the House of Representatives, and the state level. All right, in Oklahoma. In New Jersey, they call it the General Assembly, but we're actually reading it from the Supreme Court of Oklahoma in regards to the Constitution of Oklahoma. All right. This is what we're reviewing right now. All right. So in your own time, you can review points 1 through 12. But I want to go into the meat of what I'm trying to get to in regards to this case, Jones versus Freeman. All right. And this is on page 15. Okay. We know Oklahoma was not an original colony. It was not an original state as in the 13 colonies. It came about as a result of Article 4, Section 3, Paragraph 1, when the states were allowed to be admitted into the Union in lieu of those that are already created the Union of Perpetual Peace, going back to the Articles of Confederation. All right? Going all the way back to the Articles of Confederation. All right? And we know the Articles of Confederation of the second Continental Congress goes back to the Declaration of Independence. All right? The United States is the idea at this particular time. It did not come into fruition until 1789. At that time, it was an agreement between the states, i.e., colonies, and a compact that they created by giving up the sovereignty to the Articles of Confederation, i.e., the Union of States, in regards to that sovereignty that they recognize as rightfully belonging to king and parliament, which denotes to a usurpation of the royal prerogatives of the king and parliament, i.e., the crown. All right? Or the English throne. Let's get to it. Jones versus Freeman. Everybody pull it up. I'll give you a second. Now we know Oklahoma is actually Indian territory. We know Indian territory was assumed by those who created this history pertaining to America and the natives here in North America, as well as the foreigners who came here as colonists, known as the 13 colonies. They created this false narrative. All right. They created that false narrative because the French were already here controlling the territorial known as Indian Territory, now known as the state of Oklahoma. The French and the Kingdom of France, the kings of France control this territory. All right? The kings of France control this territory. All right? And we know our ancestors were called, what was that term? Free people of color. All right? Creole. They were called free people of color, but they was only deemed that as a result of the misinformation they had about that territory that they now existed in, and those who were the actual owners of that territory, which they were actually descendants of, until they were uh, 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 misguided by misinformation. All right, as a result of what we call slavery. All right, slavery of your mentality. I'm not talking about slavery in chains. I'm talking about slavery of your mentality, because the slavery in chains was subject to the slavery of mentality, which still goes on today. All right, you still are enslaved. They just took the chains off. All right, it just took the chains off. Why? Because you consented to the slavery. You no longer rebelled against the slavery. You consented to the slavery. All right. As a result of you recognizing you're not being equal to them, as a result of the status in reference to citizenship of the perpetual union of the 13 colonies, as well as those admitted into the union by Article 4, Section 3, Paragraph 1, as stated, which are now 15 states that now practice slavery with their citizens. All right? Because you are still deemed American citizen, whether you on the federal level or state level. You either can fall in 3 categories: a federal citizen, a state citizen, administrative citizen, or a corporate citizen. 4. All right? Corporate administrators are one and the same. All right? I don't give a damn what you call yourself outside of your being associated with society. You can do that. You can do that all day, but you're gonna have to come to terms with the society that you're a part in and your relationship to that society, in regards to the uniformity of equality. All right, on the uniformity of equality, because this is what this whole thing is all about. Let's get to it. Jones versus Freeman, right? Indeed, the principles of the Declaration of Independence are adhered to within its terms. All men are created free and equal. Rousseau's social compact embraced the idea of equality, as does our constitutional requirement for uniformity of taxation. This is Oklahoma Constitution, Section 5, Article 10, Section 30, Article 10 of the Constitution, and for uniformity of equality of laws, Section 59, Article 5 of the Constitution. So the main two things that they're concerned about in regards to the state of Oklahoma is uniformity in taxation and uniformity in equality. All right? No different than what the colonists was talking about when they rebelled against Great Britain. No taxation without representation. All right? And we're talking about the House of Representatives, who's supposed to represent the citizens or the subjects. All right? The citizens or the subjects. If you're talking about citizens, you're talking about the state or the federal government. If you're talking about subjects, then you're talking about Parliament, i.e., the House of Lords. And the House of Lords passed legislation that protect their subjects, carried out by the House of Representatives in lieu of representation of the people, because that's balance. It's called checks and balances. So the state of Oklahoma says that the importance of their constitution embraces 2 of the main factors: uniformity in taxation and uniformity and equality of law. All right? We would not have it otherwise. These living oracles, to which reference is made, make manifest the principles of equality on which society rests. Thus, far throughout the ever-increasing exigencies of government efforts to cope with the complicated refinements of civilization, it has been always the custom to observe that principle. You hear that? Has always been the custom to preserve the principles, not just of equality, but taxation. All right? And we know tax means debt. All right? That in under federal law is called free and common soakage. All right? Because if you have a right given by the grantor to a grantee, it's only right that you must, what they call, what it says, be made whole. All right? They say if land is taken for public use, whoever the land was taken for must be paid for, or some type of recompense must be given. All right? So as they said, the 2 main things in regards to maintaining what they call for the refinement of civilization is the uniformity and what they said, equality and uniformity in taxation. Let's move forward. And that's case law in reference to that. The challenge of the colonies to King George as prelude to the war was that ignorance of a fact because of the absence of prejudice affords no excuse to deny right of suffrage, whereas ignorance of law does. So the colonies recognized that you had a right to suffrage, in spite of there being no prejudice. You had to seek redress if you are being injured. The only way you can't seek redress in lieu of an injury is the result of ignorance of law. All right? Their slogan under the colonies was expressed as was expressed by Oklahoma and their constitution, uniformity of taxation and uniformity of law, was expressed in the slogan as which were familiar words as deemed by the Articles of Confederation by the colonies, now called states. Taxation without representation is unjust. And when the yoke of a government not responsive to the needs of men was broken, it was largely because government had denied equality and representation. All right? Denied equality and representation. In proportion that suffrage is denied or withheld, the government becomes oligarchical or monarchical, to which no people worthy of freedom will submit. So monarchical deals with the king and his parliament, and oligarch, pardon, let me say it again. Monarchical deals with the king and his parliament or his legislative council, or oligarchical deals with just an assembly of men headed by a president and his council. All right? Which no one will submit to if they're not dealing with what? Equality. If they're not dealing with equality. It says, when as decided by the majority, each voter in Marshall and Love County districts number 26 had over 8 times as much voice in the Senate as each voter in Tulsa County. So they're talking about the House of Representatives and the Senate in regards to the Electoral College, which is how members or officers or commissioners are elected to their office by way of what we call voting. All right? So they're talking about the districts within those counties in regards to the amount of representation in lieu of being elected by those voters. All right? So I start again. When as decided by the majority, each voter in Marshall and Love County District number 26 had over 8 times as much voice in the Senate as each voter in Tulsa County District number 31. It is to say that 7 men out of every 8 in Tulsa County are not represented at all. They are required to submit to taxation without representation. All right? They are required to submit to the taxation without representation. It was this kind of oppression which inspired that great struggle for freedom, which began in Lexington Green in 1775 and ended in Yorktown in 1781. No citizen will or ought to love the state which oppresses him, and that citizen is arbitrarily oppressed who is denied equality of representation with every other citizen of the Commonwealth. All right, we know Commonwealth goes back to those that were subject to the authority of the crown. Equality of representation is the basis of patriotism. Thus, it is sought to make plain that the issue presented in the cause at bar is not merely a political question involving identity of the legislative members. Indeed, the present legislator has hereto adjudged that as such a body has a right to do. So they're talking about questioning your legislators. All right, the House of Representatives and the House of Senate, with Marbury versus Madison, do what we call a writ of mandamus called warranto, they wouldn't do. All right, because why would the judiciary not issue a writ of mandamus on behalf of the executive officers who wanted the judiciary to issue a writ of mandamus? Why? Because the judges knew what they were doing were unlawful. All right, they knew that the office had to be held by somebody, whether they were de facto or de jure. Because there is no office, then there's no reason to argue de jure or de facto. All right, so the only person that can raise that issue is the citizens themselves, based off their obligation to hold those persons sitting in office responsible. All right, responsible. Equality of representation is the basis of patriotism. Thus, it is sought to make plain that the issue presented in the cause at bar is not merely a political question involving identity of legislative members. Indeed, the present legislator has hereto adjudged that as such a body has the right to do. Section 30, Article 5, under the Oklahoma Constitution, Section 30, Article 5. But according to our recent decision in State X Cloud versus State Election Board, ETAL, let me go back up. The provisions of Section 30, Article 5 of the Oklahoma Constitution do not divest the Supreme Court of jurisdiction to determine upon the eligibility for election of members of the House of Representatives, nor has this court hesitated to adjudge whether or not a legislator is in session. Simple versus Hill. Nor has this court been without the power to determine that a purported legislator is not a legislator, but a mere assembly of citizens without rights, save in their own proper person. Repeat again. Nor have this court been without power to determine that a purported legislator is not a legislator, but a mere assembly of citizens without rights, save in their own proper person. That goes back to my explanation dealing with the legislative council and just a council. All right? Our legislative council operates by way of what we call royal instructions, or by way of what we call the commission by commissioners, which is in this case about what we call royal prerogative issued by the king and by his legislators. All right. We know that the United States is not a legislative council. All right. They are not a legislative council because the legislative council is controlled by the executive branch. And this is the reason why the legislators should be held in check, as well as the executive department held in check by the judiciary. And the judiciary is the king's bench who deals with the prerogative writs. All right, let's get to it. Upon this pronouncement, as reflected by the majority opinion, a rule of law is promulgated that the Supreme Court may not try titles to legislative office or enjoin the payment of legislative salaries, i.e. taxation, i.e. debt. I dissent. It will not be denied by any of my associates that the pronouncement is dictum, i.e. meaning of some pronouncement of authority. Once again, I dissent. It will not be denied by any of my associates that the pronouncement is a dictum, being the expression of an opinion or a point of law arising in the case, which, however, is not necessary to the decision of the case. That is therefore not binding on other judges. Remember, when you see case law, sometimes when case law is issued, they tell you in the top corner that this case is not precedent and not to be used in any other case. All right? And to show you that. So once again, I dissent. It will not be denied by any of my associations that the pronouncement in dictum, i.e. the expression of an opinion, which is called arbiter dictum. So by being the expression of an opinion on a point of law arising in a case, which, however, is not necessary to the decision of the case. That is therefore not binding on other judges. By other justices amongst the minority, it is thought that the pronouncement is arbiter dictum, which means an opinion authoritative pronouncement, being a saying or an expression by way of an opinion not necessary to the judgment given a record and consequently of less authority. So that means that the opinion based off those given by the justices is based off of arbiter dictum, which means it's based off an opinion authoritative pronouncement that has no basis of law. That means that it's an announcement of is what they call is of error. So it's an order of error. Moreover, it is thought by at least one justice dissenting that the pronouncement is mal arbiter dictum and consequently erroneous. All right? Mal arbiter dictum means crazy opinion authorized as a pronouncement. All right? An opinion. Most of the judges, when they decide cases, they give a statement of reason or opinion. But the statement in reason or a statement of reason or the opinion might not be based off law and fact, because the only thing that a judge can rule off or make decision off are law and fact. If there's subject matter dealing with evidence, that's left for a jury to decide. Okay? That's left for a jury to decide. So when most cases are dismissed with prejudice or without prejudice, it's either based off of deficiency. You failed to do something based off a rule. All right? When the rule itself is erroneous in its nature. A part of the arbiter dictum that is not crazy or mal is that the present but adjourned legislature consists of de jure members in sufficient numbers, both in the House of Representatives and Senate, that no doubt can be cast upon the validity of acts hitherto passed by the legislator. So, as we see here, we're seeing a difference between a de jure legislator and a de facto legislator, because it's said that legislative council of just an assembly of men separate from the rights they have in their private self. Let me go back to that quote. Where was that at? Where was that at? Right here. All right. It says, nor has this court been without the power to determine that a purported legislator is not a legislator, but a mere assembly of citizens without rights save in their own proper person. So that takes you back to what we call the United States legislators, the United States legislator. They're nothing more than just a council, all right? A mere assembly of citizens acting as commissioners on a commission, i.e. an incumbency. All right, that's all they are. They're not a legislative council. Why? Because they're not based off the royal prerogatives, as we're going to see explained here in Jones versus Freeman and the Oklahoma case by the Oklahoma Supreme Court in reference to the Supreme Court, the Constitution of Oklahoma in regards to that governing the legislative branches that consist of the House and the House Representative and the Senate. All right. The House of Representatives and the Senate. So we see that there's difference between the opinions, the crazy opinions that are authorized as pronouncements of orders or statement of reasons given by judges that are validating erroneous laws created by the legislator, which are promulgated by these codes, statutes, rules, etc., codes of law. All these laws are in violation of the common law. All right. A violation of the common law. Where am I at? Let's go ahead. A part of the operative dictum that is not mal is that the present but adjourned legislature consists of de jure members in sufficient numbers. So not just the de facto members, but the jure members. All right? That needs to be questioned if the officers who are sitting in your Congress, the House of Representatives and the Senators, are de jure members or de facto members, just like it should be done in the case of those sitting in what we call the parliament. All right, if they're de jure and de facto. All right, if they're de jure or de facto. It says here. All right, let me read that again. As part of the operative dictum that is not mal is that the present but adjourned legislature consists of the jure members in sufficient numbers, both in the House of Representatives and the Senate, that no doubt can be cast upon the validity of acts heretofore passed by the legislator. So, it's saying that for there to be no doubt cast upon the validity of the legislator, there must be de jure officers sitting in both houses, the House of Representatives and the House of Senate. If there is doubt to be cast upon the legislator, then that means that those who sit in the House of Representatives and the Senate are not de jure. What? They're de facto. They are de facto. You must understand this. How many of you are questioning the officers sitting in your federal government or the state or your state government? Are they de jure or are they de facto? That's what you need your act to show, because you're being taxed without representation, and therefore it's unjust and there is no equality. All right? Which was supposed to be kept in uniformity from the founding of this country. All right? Let's read. It says here, until the promulgation of the majority opinion, there was no determination that the legislative districts, House and Senate, were invalid. And whereas there may be a king, though an usurper upon the throne, nevertheless there must be a throne upon which the king may sit. This is coming from Blackstone, William Blackstone, y'all. Once again, I repeat, until the promulgation of a majority of opinion, i.e. operative dictum, that's now Mao, i.e. crazy, there was no determination that the legislative district House and Senate were invalid, and whereas there may be a king, though an usurper upon the throne, nevertheless there must be a throne upon which the king may sit. Let's move further. In 1461, on the occasion of Edward IV, Parliament declared the previous Henry of Lancaster's usurpers. So they're saying all those who sat in the House of Lancaster were usurpers of the English throne or the English crown by way of sitting as corporation sole. That's what they're saying. And once again, in 1461, on occasion of Edward IV, all right, Parliament, i.e. the English Parliament, declared the previous Henrys of the Lancasters usurpers, but to avoid great public mischief, also declared them kings de facto. And persons were punished in the ring for treason to Henry IV, not in aid of the lawful claimant of the crown. Once again, not in aid of the lawful claimant to the crown. So those who fell under the House of Lancaster in lieu of claims of the English throne over those of the House of York from Edward IV, which were both cadet branches of the Plantagenet crown, which descended from the Angevin crown established by John, the one who signed the Magna Carta. All right, this is in a case in Oklahoma, which is a state of that was admitted to the Union of the original 13 colonies. All right, making reference to a time era going back to the time of the Plantagenet crown under the authority of Parliament. All right, who is Edward IV? Let's see. Go straight to the box. Edward IV was King of England from March 4th, 1461 to the 3rd of October, 1470. Then again, from 11 April to 1471 until his death in 1483. He was the central figure in the War of the Roses, a series of civil wars of England fought between the Yorkists and the Lancaster faction between 1455 and 1487. All right? So the Yorks and the Lancasters were warring against themselves as a result of what they called the War of the Roses. All right? Edward IV deemed all the descendants from the Lancaster branch stemming from Henry IV illegitimate or de facto or usurper of the English crown. That's what's being said here. And we see this in the Oklahoma case that's being reviewed in the Supreme Court of Oklahoma, which at one time was subject to the authority of the Frankish kings, who were kings of France that were subject to the House of Capet of the Capetine dynasty, which were warring with the Plantagenet crown, who established the cadet branches of the Yorks and Lancasters through the Angevin house, which was established by John. All right, these are facts. This is Edward IV. Let's see Henry IV. Let's go back here. Edward IV. Who was his father? I mean, what house was he from? The House of York. Everybody see that? House of York. Let's go to Henry IV now. Okay. Edward IV was from the House of York. His predecessor was Henry VI. Once again, Henry VI was the predecessor of Edward IV from the House of York. Henry VI was from the House of Lancaster, and we just read in this case law in reference in Jones versus Freeman that Edward IV said that all the kings of the House of Lancaster were usurpers. All right, and Edward IV's successor is Henry VII, Henry VI, as you can see here, from which Henry VII, Henry VIII, who were descendants from the Lancaster branch, which established the House of Tudors. Okay? We must understand what's going on. All right? So Henry the Sixth from the Lancaster branch, and Edward the Fourth, part and sub. Let me get this right. Edward the Fourth of the House of York and Henry the Fourth of the House of Lancasters were cadet branches of the Plantagenet crown. All right. We see that the successor of Edward the Fourth of the House of York, predecessor was Henry the Sixth. All right, from the House of Lancaster. So Henry the Sixth preceded Edward the Fourth. All right, but it takes you back to this court case. In 1461, the occasion of Edward IV, on the occasion of Edward IV, declared the previous Henrys of Lancaster's usurpers, i.e. de facto, but to avoid great public mischief, also declared them king de facto. All right, king de facto persons, and were punished in the reign for the treasons of Henry IV, not in aid of the lawful claimant of the crown. All right, so Henry IV and Edward IV, they're from the York and Lancaster cadet branches of the Plantagenet crown. All right, we know that Henry VI succeeded Edward IV, which was from the House of York, who said that Henry VI and all his predecessors and all his successors were usurpers and de facto rulers, which means that King Henry VII, King Henry VIII, Elizabeth I, King James, all the way back to Queen Anne, all the way down to King George I, all the way up to Charles, the King of England in this present day, are all de facto kings. Are all de facto kings. This is a fact. All right? This is a fact. Let's see. Because what it said here, the king must have a throne. Where is it? Right here. Until promulgation of majority opinion, there was no determination that the legislative district, House, and Senate were invalid. And whereas there may be a king through an usurper upon the throne, nevertheless, there must be a throne upon which the king may sit. And that's called the corporation soul or the crown or the English throne. That's what they're talking about. All right? In a nutshell, let's continue. This court recently held that there can be no de facto officers where there is no office to fill. There can be no de facto officer when there is no office to fill. Once again, the court recently held that there can be no de facto office where there is no office to fill, and there can be no de facto office when there is no office to fill. All right? When there's no office to fill or where there's no office to fill, that's called an interregnum. All right? That's called an interregnum. All right? When there is no interregnum, then that means that rex NUNQUAM mortier. The king never dies. That's no sort of demise of the crown. Demise of the crown is the transfer of the crown. All right? Or the conveyance of the crown to what they call coronation ceremony. All right? Let's continue. The bill was supplemented by the rule promulgated by the Supreme Court of the United States in Norton versus Shelby County in Tennessee. while acts of de facto incumbency means a requirement or obligation or uh, uh, obligation or rule uh, or a rule, requirement, or a law, something that you got to follow. While acts of de facto incumbents of an office lawfully created by law and existence are often held to be binding from reasons of public policy, the acts of persons assuming to fill and perform the duties of an office which do not exist de jure can have no validity whatever in law. Did you hear that? So that goes for those kings that just talk about, as well as the officers sitting in the House of Representatives and the Senate right now. They're de facto officers, but the office must remain until they're de jure officers there. And the only de jure officers can be there is king and parliament under the royal prerogatives. And then under the royal prerogatives, you are able to question those who are in office. Why? Because they have pledged themselves under oath. Y'all don't understand. Let's continue. The doctrine said the Missouri court presupposing an office which the law recognizes. Mere possession of a public office is insufficient to make incumbent a de facto officer. Possession plus color of title to office, if offices actually exist, is sufficient. Mr. Justice Field and Norton versus Shelby County super resided for the Supreme Court of the United States, but it's contended that if the act creating the board was void and the commissioners were not officers de jure, they were nevertheless officers de facto, and that the act of a board as to a de facto court are binding upon the county. This contention is met by the fact that there could be no officer either de jure or de facto if there be no office to fill. You hear that? There could be no, if the contention is met by the fact that there can be no officer either de jure or de facto if there is no office to fill. All right? So that's the reason why they took out corporation sole, because now you can't hold them responsible for being de jure or de facto, because they separated the fusion of government to a separation of government. All right? They're running roads, y'all. I tell you, they're running roads. As an act attempting to create the office never became a law, the office never came into existence. All right? Then the office never came to existence. That was their intent and purpose for the Articles of Confederation. Let's continue. Now, if the majority opinion is correct to the extent that the legislative apportionment acts are unconstitutional, and that the provisions in the Constitution for legislative apportionment had spent its force, something more than a mere apparent existence of the legislative office is necessary to give validity to the acts of the present and future legislators, both House and Senate, for the interpretation of law obtains the force of law. If at all possible for the public good, condemnation of all apportioned law should not be extended, because, as the Supreme Court of the United States said, an unconstitutional act is not a law. It confers no right, it imposes no duty, it affords no protection, it creates no office. It is in legal contemplation as inoperative as though it had never been passed. While there might have been in the past under condemned legislative apportionment laws de facto legislators, and while there may be some now, and while their acts may be constitutional, and especially that of legislative adjudication as to who the members were and are, when we lose sight of the legislative apportionment provided in the Constitution, or adjudge that it has spent its force, we adjudge that there is no district or legislative office from which the next legislator may be elected. So the office must be maintained in order to fix it. Don't throw the baby out with the bathwater. Why you're not taking place? That's why Jesus said he was arguing in the temple with the doctors of law. He was in the courtroom. All right? Because we're dealing with a review of judiciary in regards to those who make the law. And if the judiciary is holding up laws that are that are de facto, all right, or a color of law, then that means that it should never be in existence from the door, from the origin from which it was created, and equality. All right? Let's move forward. Let me slow down. If we give sanction to the legislative districts and offices created by the Constitution, we then contemplate districts from which legislators may come, more or less, and constituents which they may represent, more or less. I am less sanguine than a majority about the assumption that the next legislator will enact a new and proper apportionment statute, or that the people through an initiative will do so. The initiative has been found cumbersome and subject to contest, and the people are engaged in great war efforts. It may be inquired upon whom did the primary mandatory duty rest to discharge the obligation imposed by the Constitution? Question mark. The answer is plain. The 18th legislature, section 10b, article 5 Constitution provides that the apportionment of this state for members of the legislature should be made at the first section of the legislature after each decennial federal census. Now, upon whom does the secondary mandatory duty rest to review and enforce a legislative apportionment? Question mark. The answer is equally plain. Section 10, paragraph J, Article 5 Constitution, which provides an apportionment by the legislature shall be subject to review by the Supreme Court at the suit of any private citizen. Did you hear that? At the suit of any private citizen. And we talking about the Oklahoma Supreme Court telling you this. The Constitution of Oklahoma is telling you this. All right? The history that was there prior to Oklahoma or Oklahoma Constitution is telling you this. All right? The de facto officers who are sitting in these offices are telling you this because the office must remain. Yeah, they just usurpers, they not disagreeing with that, but the office must remain. Because if the office don't remain, that means there is no estate, there is no inheritance for which the king is able to revert back on behalf of his royal prerogative. Why? Let's prove this. The duty rests upon this court according to Section 2, Article 7 of the Constitution of Oklahoma, which invests the Supreme Court with the power to issue writs of mandamus, court warranto, writ circulator, and prohibitions, and such other remedial writs as may be provided by the law. And also to determine the same, and the Supreme Court may exercise such other and further jurisdictions as may be conferred upon it by law, whereby this court has power to afford relief. It has never been doubted in this country since Marbury versus Madison that an act of the legislative department of government contrary to the Constitution is void and is subject to the declaration by the courts. Indeed, it was never doubted by the prior to Marbury versus Madison that an act of the legislative department of government contrary to the Constitution was void. This matter has previously been set at rest in Holmes versus Walton in 1779 in New Jersey, which was the first case heard under in New Jersey under the common law. First case heard. All right, case law to support that. In Virginia, by George, well, we're gonna move down a little further. Right here. The old courts of appeals under the Articles of Confederation. Did you hear that? The United States Supreme Court ain't even in existence right now. All right? The Union ain't even in existence right now. All right? We knew that King and Parliament and the royal prerogatives of King and Parliament were surrendered to the Articles of Confederation by the colonies. Right? And the power that the colonies surrendered to the Articles of Confederation was the rights, royal prerogatives that they rightfully recognized belonging to the King and Parliament. Okay, so it just said here, the old courts of appeals under the Articles of Confederation denounced as unconstitutional. Let's go up here. Denounced as constitutional law that assigns circuit duties to judges of the appellate tribunal. Judiciary debates of Congress, 1802, and ancient British president. All right. This is what you call your right to suffrage. All right. Based off precedents and lieu of presumptive evidence. All right. But there is no right of suffrage in ignorance of the law and lieu of that precedence and lieu of right of suffrage in regards to presumptive evidence. All right, because your presumptive evidence is what I'm giving you now, going back to time immemorial. Because in Jones versus Freeman, what I'm reading to you right now, it says that on page 29 in American Law Review, it states in the Doomsday Book, it was decided what power the king has, he has by law. The greatest inheritance that the king has is the law. For is there for if there was no law, there will be no inheritance and consequently no king. Did you hear what I just said to you all? If there was no law, there would be no inheritance and thus no king. Because the king is to protect the estate that's entail, which is called crown land, right? Which is a lodium, because it belongs to the king under his jewel regalia. You must understand this. Let's get to it. The greatest inheritance that the king has is the law. For if there was no law, there will be no inheritance. Consequently, there will be no king. Long prior to the decisions in Marbury versus Madison, Virginia and Kentucky, under a policy of state rights by resolution, had declared that the sovereign states had a power to disregard unconstitutional acts of Congress and to exercise the state right to make the determination. The doctrine had been suggested at the Constitutional Convention with the idea of creating a council of revision, i.e. law revision, to exercise corrective influences over excessive or aggressive acts of Congress by creating statutes and codes or which are contrary to what the legislative promulgated. The philosophy of the Virginia and Kentucky Resolution had become the ruling doctrine of the Republican Party. The author of the Creed of State Rights sat in the president's chair. You hear that? The author of the Creed of State Rights sat in the president's chair. He was Thomas Jefferson. My last name is Jefferson. All right? But I'm not a de facto officer. I'm a de jure officer because under the Article of Confederation, no religious test is required for holding a public trust in reference to the public trust doctrine in regard to the public trust that has to do with the estate, i.e. of inheritance, that you call the cestui. All right? Political questions determined by the Supreme Court. Political questions determined by the Supreme Court was by and through a decision amounted to a mere repetition of familiar law, but it was not enforced by issue of a writ. That political issue was whether the state has the right to pronounce a federal law unconstitutional. That's what Holman Walton was all about. Unconstitutional, and so null and void, or whether that power would be exercised by the federal judiciary. Marshall challenged politically and made the issue. He was an actor in the matter before him as a judge. The court declined to afford relief, and not for the side reason that the judges will not to do so, but because the court erroneously held that the 13th section of the Judiciary Act of 1789 was unconstitutional in conferring upon the Supreme Court the power to entertain the original jurisdiction and the character of the case then before the court. That court, like the majority of this court, paid no attention whatever to the clause of the federal constitution which provided as to the original jurisdiction conferred by the federal constitution with such exceptions as the Congress shall make in view of which the power conferred by the constitution was not exclusively in the rule expresso unius exclusio alteris and did not apply. All right, let's move forward. Okay, let's go right here. All right, let's start here. However, the framers of the Constitution intended that the legislative apportionment contained therein should serve only until 1911. The Constitutional apportionment was intended to only be temporary. Of course, the framers of the Constitution intended that the apportionment provided in the Constitution should be superseded decentrally, forgive me if I pronounced that wrong, only by a valid legislative act adjusting representation, and the House and Senate as equally as may be. And to this end, specifications of equality, compactness, and limitations on numbers of senators were detailed in that Constitution. All right? And equally true, the framers of the Constitution made certain that there should be no hiatus in government. It was well known to them that without valid provisions for an office, not even an usurper in office, could, when challenged, lawfully remain to perform the functions of government. That by unconstitutionality and consequent invalidity of apportionment statutes or failure to enact them, there will be no valid provisions for or creation of the legislative offices, with the result that there would and could be no further legislative departments of government. That without a legislative department of government, Oklahoma would fail as the government Republican in form, and that such a government was required by the federal Constitution, Section 4, Article 4, and that a means was therein provided to enforce requirements. The United States shall guarantee to every state in the Union a republic form of government, and shall protect each of them against invasion on the application of the legislature or of the executive when the legislature cannot be convened against domestic violence. That means violence at home. That in all probability, domestic violence as a result of chaos would ensue if a de jure or de facto legislature could not be convened. Anglo-Saxon civilization for a rule of law, Rex NUNQUAM mortier, and to avoid such chaos and violence, the Constitution was constructed to provide. Section 10, Article 5 of Oklahoma Constitution. So Rex NUNQUAM mortier means the king never dies. All right? And I'm taking to the last article. Right here. Checks and balances, said Mr. Justice Brandeis and Myers versus United States, were established in our government in order that this should be a government of law and not of men. You hear that? Because when men create law, such as artificial law, then they make law for artificial people. All right? Men don't supposed to make law for artificial people, i.e. corporations, i.e. legal persons, legal entities. Men are supposed to create law for men. And if men is created in the image of God, then the law that men create in the image of God must be God's law. So that means that there should not be a separation of church and state. There should be a fusion of church and state, i.e. a fusion of government, because God runs the government. When I say God, man is representation of God, i.e. government, ordinance, the parliament, i.e. king and parliament. All right? To prevent abuses, the barons wrestled with John at Rudiment. The various guarantees of the Great Charter and stipulated therein rights should not be sold, delayed, or denied, and that the king should appoint justiciaries, sheriffs, and bailiffs of such as know the law of the land and are disposed to duty to observe it, to observe it. That's a pledge. When you go to every courtroom and any court in the state or federal level, who do you see there? A sheriff. All right? A sheriff. Let's move forward. So as they said, 1 second. Hey, Queen.
In lecture?
Yes.
Call me back.
Okay. Everything okay?
Yeah.
Okay. Sorry about that. All right. So as it said here, to stop the chaos in regards to who are the de facto officers and the jure officers sitting in the office of king, the people must discharge that will. All right? The people must discharge that will by way of what we call prerogatives, petition under the royal prerogatives. All right? That's what you must do. That in all probability, domestic violence as a result of chaos would ensue if a de jure or de facto legislator could not be convened. Anglo-Saxon civilization afforded a rule of law, Rex NUNQUAM, and to avoid such chaos and violence, the Constitution was constructed to provide. As we know, it is said that there must be the king's throne. Whether the office is de facto or de jure, there must be the king's office. It must be there. All right? And you know, king office, as explained earlier in this lecture, represents king and parliament, which is based off the legislative council, which consists of the royal prerogatives, which are still present in the legislation, in the constitution, and the statutes, as well as in case law that I provided for you today. All right? That I provided for you today, which mentioned your ancestors who put this writing in law, who put it in writing. All right? Where we at? So we know when they gave the example with Edward the First, let me just go here real quick. Right here. Edward the Fourth said that the House of Lancasters and all those who descended from the House of Lancasters, which are those who descended under the House of Tudors, under Henry VII and Henry VIII, were the ones responsible for all the property belonging to the church being put in what they call a trust. All right? Henry VII and Henry VIII from the House of Tudors descended down from the House of Lancasters, which were de facto officers. They were de facto officers going back to Edward I. That takes me back to the Treaty of Westminster. Of 1462. All right. The Treaty of Westminster, or Treaty of Westminster, Artonish, was signed on the 13th February 1462 between Edward IV of England of the House of York and the Scottish John Islay, Earl of Ross, Lord of Owls. All right. Let's go to the background. Okay. All right. Now we know that Edward IV said that all the descendants of Henry IV were usurpers or de facto officers. That was just repeated in Jones versus Freeman. All right? Edward IV of the House of York said that all the descendants of Henry IV of the House of Lancasters were de facto usurpers who were sitting on the throne of England called the crown as corporation sole. Okay? That's what he said. And we know that Edward IV successor was Henry VI. So Henry VI was a de facto usurper of the English throne as a result of the War of the Roses. All right? Right here it says, and the Treaty of Westminster of what was it? 1462. The Scottish crown in the minority of King James, the Scottish king, had taken the Lancaster side in the War of the Roses by welcoming the fugitive Henry VI of England, the successor of the predecessor Henry the Edward IV, who declared them all usurpers and illegitimate, the one you just read in John Jones versus Freeman. All right. Edward IV was forming a new alliance with dissatisfied English and Scottish nobles to reduce the threat posed by the exiled former kings, now in the hands of James III, Mother Mary of Guildford. All right? You see it right there. So that's the Treaty of Westminster. All right? And we know that all the property held in Finninger goes back to the Norman Conquest. All of it goes back to the Norman Conquest. All right? Norman Conquest, when William the Conqueror gave out tingers to his descendants, who were Northmen, Vikings, who were of Frankish, Visigoths, and Lombardians descendants, who descended from the Carolingians and Merovingians. All right? William claimed the English throne, i.e., the crown, derived from his familial relationship with the childish Anglo-Saxon king Edward the Confessor, who encouraged William's hope of taking the throne of England. All right, let me go a little further right quick. They talked about the Doomsday Book, right, in that court case. I ain't gonna go into that for the second time. Let me move forward. Okay, so the Norman Conquest came about when the feudal tingers was introduced, all right, by William the Conqueror. All right, that takes you into the Treaty of Westminster of 1153. Treaty of Wallingford. Because you see here, Wallingford and the Norman Conquest. Right here. Stignash, Smith League, October. All right. So we go back here to the Treaty of Wallingford, which is right here. That takes you back to 1153. Right. This is after the Norman Conquest, when you get into dispute between Stefan and Matilda, who was the daughter of Matilda of Scotland, the wife of Henry I, the son of William the Conqueror, who invaded England. All right? The Treaty of Wallingford was an agreement reached in England in the summer of 1153. It effectively ended a civil war known as the Anarchy. All right? And it caused by a dispute over the English crown, i.e., the English throne between King Stefan and his cousin Matilda. The Treaty of Wallingford allowed Stefan to keep the throne until his death, but ensured that he would be succeeded by Matilda's son, Henry II. All right? Henry II, the son of Godfrey. All right? Henry II. House of Plantagenet and Gibeon Crown, which was the founders of the house, the Yorks and Lancasters, where Henry VIII descended down from, who put all of our intel estate in a trust, which you call a cestus quae, all right? And the trust that was established going way back to the Plantagenet Crown when William the Conqueror surrendered under the Treaty of Westminster of 1153, William the Conqueror became trustee of it as well, all right? And it was left in the hands of the Roman Catholic Church because William the Conqueror was head of the Church of England, which goes back to St. Augustine of Canterbury, which had all the Anglo-Saxons converted to Christianity. All right? But as we can see that, as we see in Jones versus Freeman when it said that all usurpers or de facto rulers sitting on the crown or that office were descendants, were usurpers of Edward the Fourth. Edward the Fourth descended down from Edward the Third, and Edward the Third descended down from Edward the Second, and Edward the Second descended down from Edward the First, and Edward the First was the one who was warm with the Scottish kings who sided with the Lancaster side as a result of the conflict between the cadet branches of the Yorks and Lancasters, which were all the cadet branches of the Angevin Plantagenet crown, which we're reading about right now. Okay, which you've seen in that case of Oklahoma, dealing with all the indigenous people of what we call North America and the territory encompassed by the Kingdom of France, which was at war with which was headed by the House of Capet, which was established the Capitan dynasty, which was warm with the Plantagenet dynasty. All right, the Capitan dynasty war with the Plantagenet dynasty, who was headed by Godfrey the Count of Anjou, son of Fulk, ruler of Jerusalem. Okay, these are stone cold facts. All right. Demise of the crown. Demise of the crown relates to Rex Rex NUNQUAM moritiur, which means the king never dies, which denotes to what they call demise of the crown. All right, a demise of the crown. Let's just go to the meaning. Real quick. English origin, meaning of term. The term demise was originally a law French term used for the transfer of real property, whether by lease or sale. All right. Blackstone notes that this term was the transfer of property, then became used on the death of the monarch to mean the kingdom is transferred or demise to his successor. Demise is not referring to the monarch's death. You hear that? But to the automatic transfer of the monarchy to the heir by operation of law through dispensation in regards to the inalienable estate. All right? Blackstone states in his commentary, a third attribute of the king, i.e. the Trinity, of the king's majesty in his perpetuity, the law ascribes to him in his political capacity and absolute immortality. The king never dies. Henry, Edward, George may die as natural people, but the king survives them all. For immediately upon the decease of the reigning prince in his natural capacity, his kingship or imperial dignity by acts of law through dispensation by way of statute without any interregnum or interval is vested in one of his heirs who is il instante, king in all intent and purposes, i.e. corporation sole. Okay? Corporation sole. Let's go here. Indian Territory. In closing, while Congress passed the Organic Acts, provided a path to statehood for much of the original Indian country, Congress never passed the Organic Act for the Indian Territory. Indian Territory was never an organized territory for the United States. In general, tribes could not sell the land to non-Indians. Johnson versus McIntosh. Did you hear that? Native Americans, Indians on the territory known as Indian Territory, now called Oklahoma, which is now a state, the territory cannot be sold. All right? It cannot be sold. Why? Because it was crown property. Let's prove it. Ward versus Keenan. Martin versus Waddell. So they made reference to the Aboriginal Native American Indians, and they had a court case, Johnson versus McIntosh. All right. We're not reading Johnson versus McIntyre. We're reading Ward versus Keenan. All right. Martin versus Waddell. Sorry. And in lieu of this inheritance, which is land, which is part of a fiefment, i.e., why? Because it's Lodio, which was left in the trust, i.e., Sestuke, right? Which did not belong to Henry VIII, who put it in the trust because they were the usurpers of the trust as a result of them sitting in the office as corporation sole on the authority of the crown as de facto officers. All right? As de facto officers. We must understand that. The English possessions in America were not claimed by right of conquest. All right. We know that William the Conqueror invaded the throne of England by right of conquest, then started this right of discovery mess. All right. He's the one who conquests the English throne by usurping the houses of the cadet branches of the Plantagenet crown, the Yorks and the Lancasters, with the assistance of the Scottish kings going all the way back to James III. All right. The English possession in America was not claimed by right of conquest. Why? Because it was intel, but by right of discovery. All right. Why? Because right of conquest was done by way of the House of Tudors when we were warring through the War of the Roses through the First and Second 100-Year War. All right. Once that was done, then they started the right of discovery. For according to the principles of international law, as understood by the then civilized powers of Europe, the Indian tribes in the New World were regarded as mere temporary occupants of the soil. All right? And the absolute right of the property and dominion were held to belong to the European nations by which any particular portions of the country were first discovered. Whatever forbearance may have been sometimes practiced toward the unfortunate aborigines, either from humanity or policy, yet the territory they occupied was disposed of by the government of Europe at their pleasure, as if it had been found without inhabitants. The grant to Duke of York, therefore, was not a land won by the sword, nor were the government or laws he was authorized to establish intended for and conquer people. The country mentioned in the letter patent was held by the king in his public and regaled character, I adjure regalia, as the representative of the nation and trust for them. The discoveries made by the persons acting under the authorities of the government were for the benefit of the nation and the crown. Y'all better be listening. According to the principles of the British Constitution, was the proper organ to dispose of the public domain, and upon these principles rest the various charters and grants of territory made on this continent. All right? This is Martin versus Waddell, and the doctrine upon this subject is clearly stated in the case of Johnson versus McIntosh, point 595. We'll see that in 1 second. Let's go to 414. Okay. So they were talking about Charles II, charter given to Duke of York, was established the land grants given here in North America, what they're speaking about, which belong to the crown. You know what I'm saying? And those who received letter patents was not for their private interests, but for the crown, i.e., for the crown established government at that particular time. This opinion is confirmed by referring to similar grants for other countries upon this continent, made about the same period of time. Various other charters for large territories on the Atlantic coast were granted by different monarchs of the Stuart dynasty to different persons for the purpose of settlement and colonization, and which power of government were united with the grant of territory. All right, let's go to 433. Right here. So in light of what we just read in this case, Martin versus Wardell, before we go to Johnson versus McIntyre, point 559, 595. It states here in closing in this case law in the dissent, it states, and I can discover nothing in the authorities given in the countenance to the idea that the king held the land covered by waters of a navigable river as trustees or by a tenure different from that by which he held the dry land. And I must remember, feudal tenure was created under William the Conqueror when he invaded England and France as a Norman and by a Norman Frankish descendant. All right, which goes back to the Carolingians and Merovingians, which made their way here to North America. All right, which was always a part of what we call the English Empire. All right, going back to Albion. It says here, and I must again repeat, if the king held such land as trustee for the common benefit of all his subjects and inalienable as private property, I am unable to discover on what grounds the state of New Jersey can hold the land discharged of such trust and can assume to dispose of it to private and exclusive use of an individual. If it was a trust estate and a king for the benefit of his subjects, then upon the revolution, the government of New Jersey became the trustees in place of the king, and the trust evolved upon such government, and the land became as inalienable in the government of New Jersey as in the hands of the king, and the state must be bound to hold all such land subject to the trust, which, as contended, embraces a common right of fishery in the waters and the dredging for oysters in the land covered by the waters. And if this be so, there certainly can be no power in the state without a breach of trust to deprive the citizens of New Jersey of such common right of convert these oyster grounds to private and exclusive rights of individuals. Okay, these are facts. Let's go to Johnson versus McIntyre. 595. Because that's what it took us to, right? It says here, in regards to Indian territory, dealing with the 5 civilized tribes of North America, in regards to them being mere occupants on the land. Why? Because all claims made to the land was presumed by way of what we call right of discovery. And we know right of discovery comes by way of those who were doing discovery off of those sent by way of on behalf of the Spain and France. All right, Spain and France, as well as Henry VIII. All right, Henry VIII was the founder of the House of Tudors, and he was a part of the affiliation of the Lancaster branch, which were all usurpers and de facto officers who usurped the English throne, which, as a result of that usurpation, that all assets of the throne, i.e., real estate, not paper wealth, but real wealth, was put in a trust called a cestui, known as the feastment, which was under the authority of those given letter pad, i.e., deeds. All right, which the United States holds the biggest one. All right, it's called a charter. And we know that the charter that the United States had under the Articles of Confederation is null and void as a result of the charter that preceded it, which was under the proprietors, which surrendered back to the crown, and the perpetuity of the crown was perpetual and indefinite. All right, let's move forward. Villain versus Harris. It was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was invested with all the powers of the King's Bench, all right, which the legislator was powerless to cut down or to assign to other courts. Why was the legislator powerless to assign the King's Bench to other courts as a result of what the legislator said? Because the legislator was under the control of the king, under the legislative council of the king, i.e., king and parliament, under the authority of what we call the crown. All right? It's right there. It's right there. All right? We know that if there are no heirs and the land going to its chief as a result of being no heirs, then it results to the crown. And the crown is represented by the king, but the king is not there as a result of the powers or prerogatives or royal prerogatives of the king were surrendered to this government that we're now subject to. So the only way that the royal prerogatives that can invoke the prerogative of the crown is by way of what we call a private citizen. All right? As Chief Justice Vanderbilt said, which was the first Chief Justice of the Supreme Court of New Jersey by way of the amending of the Constitution of 1947. All right? Which can still continue the force of law of the common law of England, which validated the laws that were created by the King's Bench and that the legislator could not separate. Why? Because that was the law that the King's Bench swore to uphold. All right? They swore to uphold. Ward versus Keenan. Right here. Now, as we read Jones versus Freeman, in regards to the uniformity of taxation and uniformity of equality that was done in the state of Oklahoma, as well as the same argument or the same model, it was modeled after the colonies under Articles of Confederation in lieu of taxation without no representation. All right? Taxation without no representation, because the government at that time under the colonies was the king and parliament. So if you're a subject, the only way you can be, you can receive what we call right of suffrage is by way of a private citizen invoking the prerogatives of the crown. All right, in lieu of judicial review of the prerogatives of the crown, by way of writ, which can bring into question their injuries that are occurring as a result of those who hold those office de facto, not de jure. It says here, thus it is habitually used as a remedy, and we're speaking about royal prerogatives or the king's prerogatives or the king's writs. It says, thus it is habitually used. Let me go a little further here. Let me say here. Thus, it's habitually used as a remedy against unlawful taxation, either by state, county, township, or city purposes. And while this remedy has been denied in other states as dangerous or prejudicial to the public welfare, no such evil has been experienced from the use of the remedy, while it has been found eminently salutary and efficacious as a protection to private rights against oppressive and legal taxation. It is used to test the legality of elections, all right? To test the validity of bylaws of municipal corporations, to test the validity of the classing and assessing of militias under the Militia Act, to reveal the return list of delinquents and execution issued for the collection of fines imposed for neglect of militia duties, laying out a roads under an act incorporated a turnpike company, the appointment and proceedings of commissioners appointed to value lands taken by corporations for their use, and to appraise damages by special statutory authority. The special significance of broad scope of a writ circulator in New Jersey in protecting an aggrieved citizen from almost every form of improper official action is epitomized by Holdsworth. You hear that? Holdsworth in speaking of the prerogative writs generally, all right? The judicial control could be applied at the suit of a private citizen. The private citizen could set in motion the different forms and procedures open to the crown. And in addition, he could bring a civil action. This power to bring a civil action was an effective control of a control, a safeguard of liberty of the subject, and one of the best of all securities for the maintenance of the supremacy of the law, especially in regards to protecting this trust. Why? Because go back to sextu quae, and we're going to see Holdsworth's words again. Where did it say? Holdsworth. Where you at? Right here. Holdsworth. Let's go to sextu quae. I think that's where it was. I think I've seen it there. Right here. Okay. William Holdsworth quoted such scholars as Gilbert Sanders, Blackstone, Spence, and Demise in regards to the sextu quae. All right? In regards to the sextu quae, William Holdsworth, a member of Venerian professor of English law at Oxford University. All right? At Oxford University. And here we see him reiterated and where was it at? War versus Kingdom. Right there. Right there. Everyone see it. So in closing, make sure I covered everything. As you can see, what they said in War versus Kingdom by the Chief Justice Vanderbilt under the 1947 Constitution, which adopted the common law of England, they said that the private person can initiate a writ, especially a writ of circulator, informally called a petition for certification, and invoke it as one of the greatest protection at law. So that's what I did. And I'm showing you here to the highest court of the land. All right. We just read it in Bellin versus Harris that the King bench was the highest court, and that the legislature was powerless to separate the King's bench from the Supreme Court of New Jersey. All right, going back from the 1776 Constitution, the 1844 Constitution, where the United States Constitution was largely modeled after, as well as the 1947 Constitution, and the 1947 Constitution, and the Supreme Court under that Constitution. And the Chief Justice of the Supreme Court under the Constitution was Chief Justice Vanderbilt. And he himself said that the highest protection is a prerogative writ, which I issue on behalf of the King's subject, because King is the one who protects the trust on behalf of the subject, as we read in Johnson versus McIntosh, as well as Martin versus Waddell. All right? Presidents that I read to you. Here you see here, our writ was issued to the Supreme Court of New Jersey, and the quo warranto, writ of manifest quo warranto, and it states here that the Supreme Court has abandoned that authority. All right? Supreme Court has abandoned that authority. But yet, the petition for certification, called a writ of circulator, was presented to them and formally called petition for certification. And they denied that as well. Why? Because they know that the court is unlawful as a result of them surrendering that power that was invested by the legislator, as stated in War versus Keenan. And they invested in the Superior Court of New Jersey under Article 4, Section 5, Paragraph 4, pursuant to a Dorn court rule. All right. So there you see it. Your king knows what he's doing because the king understands the power of the king under the king's royal regalia, which is still recognized in his present government. All right. By de facto officers who are holding the office that's null and void. Right. Because it was never sanctioned. It was never sanctioned. For all those who are viewing this lecture, if this is the first one that you're viewing, I suggest that you go back to the first 5 videos previous to this one before you view this one, because then it will make sense to you. All right. So for all those who are able at the sound of my voice to understand what's being said to you, pledge yourself to the English Third Temple Church in your kingdom, and your inheritance will be reverted back to you in due time. All right. Pledge yourself to the English Third Temple Church of England. All right. I need the bodies. All right. I need able bodies. I can do it by myself, as I've shown. But with great power comes great responsibility. All right. So with that, I love you all. For all those who are able to contribute as gift, free and common soakage, to the English Third Temple Church, to show your patronage, you can send that donation to $ Clifford Jefferson L or the English Third Temple Church of England, as well as announcement that for all officers, there will be a meeting at 7 o'clock on Thursday. So if you're a member of the English Third Temple Church of England, and you hold a position here, you are advised to be at that meeting. All right? You are advised to be in that meeting. If you're not at that meeting, then it shows that you are acting in a de jure capacity, and as a result of that, you'll be removed from that office. All right? Because you represent King and Parliament. You represent King and Parliament, not this government, not the states, not the colleagues, not their administrations, not their citizens, not their foreigners, not their diplomatics, not their preachers, not their teachers, not their schools, not their ministries, not their jobs. Don't represent the interests of the English Third Temple Church of England and its citizens in regards to this trust that was set up from them to time immemorial. So if those who understand what's being said to you, don't let me catch you. Don't let me catch you sleeping. All right. And with that, the English Third Temple Church of England, his officer says, peace.